of the State Board of Canvassers for the 21st of May is called to order. Good morning. Couple of things before we start. We have a busy agenda this morning. Can you hear me okay? Yeah. We have a busy agenda this morning, so I wanted to lay out just a couple pieces before we get going. So as we go through, we're going to allocate 5-minute speaking times for the attorneys, for the challengers. If you're here to make a public comment, public comments will be at the end of the meeting. We're going to get through everything else first. And with that, I would ask for a consideration of the minutes from the March 20, 2026 meeting.
So moved.
We have a second? Perfect. It's been moved and seconded. Meetings are approved. I'm sorry. Oh, you know what I do? Yeah, forgive me. All in favor?
Aye.
Forgive me, I'm used to 10 o'clock starts, not 9 o'clock starts. Item 2 is the canvass and certification of the May 5th, 2026 special general election for the office of U.S. Senator, 35th District. Director Brader.
Thank you, Chair Housecamp. So this was the special election that was held to fill the vacant seat in Senate District 35, which is composed of parts of Bay, Midland, and Saginaw counties. And so the Board of State Canvassers is responsible for certifying that result. I want to again convey my appreciation for the clerks, county, municipal, and the election workers that did a great job administering this election. It's always challenging to do special elections off the normal cycle, and they also had to deal with a February special primary in addition to a special general in what's usually a lower profile race. So a lower profile date, I should say. So they all did a great job with that. There were 67,000 votes approximately cast in this election. About 6,000 of them were, 5,000 to 6,000 of them were cast for write-ins and other major party candidates. But of the top two candidates, Cheddar Green, the Democrat, received 36,575 votes, and Jason Tunney, the Republican, received 24,491 votes.
Thank you, sir. Discussion. Please. If there's no discussion, I would ask for a motion.
I'll go ahead with the motion. Based on an examination of the returns received by the Secretary of State for the May 5th, 2026 special general, I move that the Board of State Canvassers certify that the attached report is a true statement of the votes cast at the special general for the office certified by this board. I further move that Cheddar Green was duly elected for the office of State Senator, 35th District.
Second.
Been moved and seconded. All in favor?
Aye.
Aye.
There's a additional motion. I move that the Board of State Canvassers authorize the staff of the Bureau of Elections to represent the board in any recount of votes cast at the May 5th, 2026 special general election.
Second.
Been moved and seconded. All in favor?
Aye.
Motions are passed. Item number 3 is the canvass and certification. Item number 3 is the canvass and certification of the May 5th, 2026 special general election for the Emergency Services Authority of Antrim and Charlevoix County. The election must be canvassed and certified by the Board of State Canvassers pursuant to MCL 168.841. Director Brader.
So this is a provision of the election law that we don't always deal with, but for this type of ballot question that falls under Section 841 of the election law, the Board of State Canvassers actually has to canvass and certify the results. So in this case, there was an EMS district race that covered parts of Antrim and Charlevoix counties. In this race, there were 401 yes votes in Antrim and 448 yes votes in Charlevoix for a total of 849 yes votes. And there were 321 no votes in Antrim and 271 no votes in Charlevoix for a total of 592 no votes. So the ballot question passed.
Any discussion? Please. No discussion. I would ask for a motion.
Canvass and certification of the May 5th, 2026, oh, I'm sorry. Strike that. Based on an examination of the returns received by the Secretary of State for the May 5th, 2026 special general election, I move that the Board of State Canvassers certify that the attached is a true statement of the votes cast at the special general election for the Jordan Valley EMS Authority millage proposal.
Second.
It's been moved and seconded. All in favor?
Aye.
Passed. Before we touch on number 4, Director Brader, I've got our, number 4 was, I have 2 copies of agendas here. One has number 4 removed and one has number 4 in place.
Removed. That one was withdrawn. So that one of the recall petitions that was going to be on the agenda, the sponsor withdrew it. So, yeah, so there were, yeah.
Okay. Do we have any slips? Are there? Nothing. Okay. We're all used to starting at 10. Item number 5 on the agenda.
We did have the other, so there were 2 recalls. I think the item 3 is the one that was not withdrawn, right? Or is it? Sorry, my fault. I'm sorry. Go ahead, number 5.
Okay. No, 4 is
Oh,
off,
go
right?
ahead.
Davidson's off.
Yeah.
Right.
Okay. Okay. Item number 5 is a consideration of the sufficiency of the recall petition submitted by Brenda DeKuyper against Noel Mogenberg and the reasons for the recall printed on the petition. And Director Brader, I would ask you to read those reasons for us.
Sure. I could just read it, okay. I apologize if throughout the day, I apologize if I pronounce anybody's name wrong. I'll do my best. So the reasons for recall printed on the petition are Noel Megenberg failed to secure complete sexually transmitted infection testing of a defendant, victim under 13 on July 3rd, 2025. Noel Megenberg failed to consult with the victim regarding a plea on June 13th, 2025. Noel Megenberg failed to investigate sexually transmitted disease present in 4-year-old female victim on June 3rd, 2025. Noel Megenberg failed to investigate allegations made by 4-year-old sexual assault victim reporting sexual videos made by a convicted sex offender on August 25th, 2025. Noel Megenberg entered into a plea deal of 0 to 9 months for assault with intent to commit sexual penetration, dropping 2 charges of criminal sexual conduct to victim under 13 on June 13th, 2025. Noel Megenberg failed to investigate a deadly crash prior to entering into a plea on March 20th, 2025. Noel Megenberg failed to consult with the victim's family regarding a plea on March 20th, 2025. Noel Megenberg agreed to a plea of 2 counts of reckless driving causing serious impairment of a body function, dropping 1 count of reckless driving causing death on March 20th, 2025.
Thank you, Director Brader. To proceed in this item, is there an attorney here that is, or is there someone here representing a challenge to this? Is there anyone? Are you representing, are you challenging this? You are. So the way that we'll proceed is I will give you 5 minutes to make your challenge. Who is here representing the petitioner? I have 3 of you folks. Okay, and you're all here together. I will give you time. I'll give you the 5 minutes to make the presentation as challengers or as respondents after the challenger makes his case. Yes, I'm going to give each of you 5 minutes. And yes. Sir? You would state your name and spell it for the clerk. And you'll need to push the red button at the base. When you push there's a little button at the base of the microphone, sir. There you go. You're on.
Good morning. Michael Brady, Michael Brady. Good morning, Mr. Chair and members of the board. My name is Michael Brady. I'm here on behalf of Noelle Mogenberg to challenge the petition seeking her recall. I challenge this on the grounds that it does not meet the statutory requirements of being factual or of sufficient clarity, as required by MCL 168.951A. I've submitted a letter to this board. The letter is 8 pages long. It details 18 specific reasons why we believe that the recall is currently drafted. I'm sorry, the reasons for recall is currently drafted do not meet the statutory requirements. Mindful of your agenda, and no doubt you have my letter. I'm not going to go through all of those, but I'm certainly available to address any questions you might have on any of them. I wasn't trying to make it long. I'll say if anything, on the contrary, the reason itself is a large paragraph, which they're entitled to make it of whatever length. The paragraph has 8 sentences, neither here nor there, but in reading the 8 sentences, I was left as someone who is not a prosecutor in that office, who does not have the background, certainly of petitioners, or of the officer whose recall is being sought. I didn't have the background or perspective to be able to fully understand all of the different cases involved. And so I noted in my letter that, I can empathize with the electors for whom this board has a duty to make sure there's sufficient clarity and that it's factual. Because ultimately that standard is not whether something may or may not have happened as described, but rather whether it is clear, sufficiently clear, not just for the officer whose recall is being sought, but also for the electors themselves. And the standard that's in the statute is whether these two different parties, one my client, the other all of the electors who this will go before, whether they can identify the course of conduct that is the basis of the recall. And so just note of the 8 sentences, there's reference to multiple different victims. There's not clarity as to which defendant or defendants are being referenced, or even necessarily the specific crimes in every one of the sentences and every one of the different cases that are involved. There's reference to victims under 13, victims who are 4, victim under 13 who's female. There's a world in which those are the same victim, but it's also entirely possible that those are different victims. And to speak with my client as I have, I understand that office, Grand Traverse, is not a small community, and they do in fact have multiple different crimes, multiple different defendants, unfortunately multiple different victims who meet those different criteria and descriptions during the time periods that are referenced. And so it is not clear to me as a reader or to my client, and I dare say to the electors themselves, whether what is being described here is every single, I don't mean to shoot the hyperbole, but just to say that clarity is not there as written. I think I made, let's see. So in addition to that overall question, just in terms of the overall paragraph and the challenge, I think, for any reader and certainly any elector of understanding how those 8 sentences work together and what they mean and what they don't mean and what they cover and what they don't cover. There's also consistent reference, not in all of them, but maybe 6 of the 8 sentences to the statement of failure, saying that Noel, well, forgive me. I'm available for any questions. Yeah. Of course.
We have questions. Forgive me, there's something. Hold those until.
I could start. So is it your position, I just see when multiple times in here, when you talk about not sufficiently clear, it's your position then that you say it lacks specificity as to the case, defendant, victim, and crime. For each of these, you would argue that each of those items would need to be, that the case, defendant, victim, and crime all would need to be listed in order to make this sufficiently clear for each of the cases that they're
yeah.
mentioning here?
Through the chair, I don't think that every one of them needs to be. I don't think that each of those components would need to be. But for example, even just identifying the defendant, which would be the standard case in, the People versus Jones, right? They identified the defendant. There are lots of reasons, good public policy reasons, why victims are often not identified, especially for some of the victims referenced here as being minors. And so I don't think the victim would need to be identified. But the defendant could be. And in fact, that's the standard in our society within criminal prosecutions. Even the case number would provide some specificity, certainly to my client, to have absolute certainty which prosecution they're taking issue with, which of the prosecutions that county and that prosecutor conducted during the summer of 25 or the summer of 24 or any of these other dates as it related to a particular kind of criminal activity. And the failure to either include the defendant's name by itself or a case number by itself, which are both public records that are out there, either of those would provide absolute clarity, and neither of those are provided.
Sure. You have questions?
We have to find that any of these reasons is unclear in order to, no, let me put it the other way. Do we have to find that each of the reasons stated in the petition is both factual and clear in order to approve the petition? There are 8 reasons stated.
By law, every part of the reason provided has to be of sufficient clarity, factual and of sufficient clarity. And so if any single component is not, then it doesn't meet the standard, and this board has a duty to reject that petition. I'll note, maybe for petitioner, but certainly especially for the public watching, that the law provides folks with the ability to redo this. Not particularly advocating that suggestion on behalf of my client, but that would not be the end of the road for petitioners or their recourse if there is, a need for this. But this particular language doesn't meet the standard.
Ms. Cummings, do you have comments? Yes, I have a couple questions for you. This is Grand Traverse County, correct?
That's correct.
So when we talk here, I'm sorry, when we talk here about failed to secure a complete sexually transmitted infection testing of a defendant victim under 13 on July 3rd of 2025. What I hear you saying is that it's really hard for the prosecutor to figure out what case that might be involving. I have to ask you, in Grand Traverse County, was there like a whole bunch of people lined up that were under 13 getting tested for that? Were there a ton of cases going through on the 3rd of, that were being tested on the 3rd of July? I mean, I have a hard time getting my head around the fact that the prosecutor can't identify which cases these are. And I would add, by the way, in further in your letter, again, regarding one of the testing, medical testing, you assert on the one hand that the prosecutor has no way of knowing what case that is, and then the next paragraph, she identifies the fact that, well, this is confusing because the child had many diseases. It could have been many infections. That clearly tells me that she knows exactly what case it is. So I have a hard time understanding that this isn't clear to the prosecuting attorney.
So, two things. I'd refer you to the very bottom of my first page of my letter and the very top of the second page. Your duty and the standard here is not clarity just for the officer whose recall is being sought, which is, I think, the point you're speaking to just there, but also to the public as a whole. And so the question is, will any elector within Grand Traverse know exactly which case they're talking about? So there is that. Both parts have to be satisfied. It's not just one. It has to be both. To the question of, were there other, how many were going on, and other I had a similar question. I don't live in Grand Traverse, and I was wondering. And so turns out there were multiple different, I don't know that it was a line down the street as you described, but there were multiple different cases within that county where there could be, I think you referenced the first sentence, the first reason, the first case, at least in part being, question about sexually transmitted infection, defendant, victim under 13, July 3rd, 2025. So there were, unfortunately, for our society and for that particular county, there were multiple different cases involving different defendants and different victims under 13. And it need be more than one. And so whether it's 5 or whether it's 7 or whether it's a dozen, it's more than one, and it's not clear as written. Another aspect a way in which it's not clear. So the first one references failure to secure a testing of a defendant on July 3rd. Well, could it have been July 2nd? Was the failure to secure the testing on July 3rd? What if it happened on July 4th? The date and other things there, I think, introduced uncertainty, and they don't actually provide much more by way of specificity. It does provide a general range of time period. And when you look at reason 1 in our response, my client does not actually have a sense exactly which one that is. The example you gave, the other reason you referenced was, a statement that, my client might be aware of, this or that. That referenced a different case. That referenced a case in which there was and all of these facts I should, just acknowledge, of course, are tragic. Speaks to larger kind of failures within our society and the very reason why we have prosecutors' offices in the first place to pursue these prosecutions to hold folks accountable, which is exactly what my client did. But you referenced a different case which involved a victim age 4. And so for that one, that doesn't happen every day. And my client had a pretty good sense who that is. But that by itself, and not a pretty good sense. She said, there was only one victim age 4 during that summer, right? That's not victim under 13, that's victim age 4. She knew who that was.
You couldn't legally, I mean, you couldn't put a minor child's name in here to
And you don't
provide
need-
clarity.
I guess I would refer you back to, how does the court handle this? You should not include the minor child's name. You should include the defendant's name, just like the courts do. The People versus Jones, for example, doesn't identify the minor child, but that same 4-year-old, and not even about the 4-year-old, but the defendant, that clarity exists in the public records. It's how we handle this and have for time immemorial. We know exactly you can look up any criminal case by the defendant's name. There's no protection for that defendant. There's appropriate shame for reprehensible activity that they've committed. And this just doesn't do that. That provides clarity. We know which Jones, right? Lots of different Jones, People v. Jones, making up the name, of course. Was it Don Jones? Was it Frank Jones? I don't know. But it's in the case because we want to make sure that those folks who acted in a terrible way are held accountable, and that shame doesn't inappropriately accrue to someone else. So it's not about the victim's name. Give us a case number. Public records are already available by case number. Give us the defendant's name. Public records are already organized and available that way right now. If we had the defendant's name, we could look up the whole proceeding on our phones right here, right now. But you can't and I can't, and neither can the electors. And they shouldn't have to guess, because that's not the standard that's laid out in the law.
Can I make a comment?
Yes, please.
Hi, Mr. Brady. I want to reiterate and support what the chair is saying, that I found it kind of an ingenuous or disingenuous argument that the prosecutor didn't know what these cases were. I don't want to beat a dead horse here, but I think your argument about the electors and the signers is much stronger. Because when I read them, not being from the county as well, I had no idea
Right.
what it may be referring to. But the argument about the prosecutor, I don't think carries any weight. I think it would be very easy for her to figure out what these cases are. They're horrible cases. As you said, they're a failure. All of these represent a failure somewhere in society that have let all these people down. And I don't think that it would have been hard for her to figure out what those cases were. So I didn't find any of those arguments persuasive.
Duly noted, and I want to be clear that in my letter, I really try to make clear there's this dual obligation in the law
Mhm.
for this board, for both, not just clarity on one or the other, but clarity for both. In speaking with my client, for some of them, particularly again, for the ones involving a 4-year-old, she's like, yeah, look, there was only one of those. She knows which one that is. Some of the other, fact patterns are extremely specific. She had clarity there. I didn't have clarity, and I found that to be, as I, noted the top of page 2 of my letter, I found my own lack of clarity there to potentially be, not just spitting it this way, but a value in terms of empathizing with the elector who will be confronted with this language on a ballot and will be reading this whole paragraph and saying, oh gosh, what does this mean? Is this every one of these cases? Are these 8 different cases? Is this, what's the subset here? I don't know. There are questions there. And so,
For everyone in the audience, when you say elector, you mean who's signing? Who would be signing the recall petition, or are you talking about the prosecutor?
forgive me, when I say elector, I'm talking about, I'm using the language from the statute.
I know, I'm just.
Yeah, no, thank you. Yeah, thank you. And so when I say elector, I'm using the language from the statute and not talking about the officer whose recall is being sought, but instead the individual voter, registered
Yeah.
voter who's entitled to sign the petition, who would have to sign the petition, and whether they in fact have enough, information, to do so.
Yeah, I just wanted, just for people who might not know the language in the statute to understand.
Mr. Brady, I have a question about whose responsibility it is to do some of the things that are referenced here.
Mhm.
There are a number of claims that there was a failure to investigate. And I understand that the prosecutor's obligation is to prosecute based upon investigations which are conducted within the county, but who does the investigations? Do you know?
Thank you for the question through the chair. The investigations are done by, my understanding, and I confirm this with my client, is that the investigations are done by law enforcement. So that could be local police departments and/or, the sheriff's office. Some of that by intention and by structure is effectively a check and balance within our society, just in terms of different roles and responsibilities. And so there's also in turn different skill sets and staffing and expertise that are brought on to their staff. So prosecutors' offices are not only not charged with the authority or obligation to do that, they also in turn do not have police officers and other folks who have the requisite skill set and expertise to go out and conduct investigations. Instead, as, you know, as noted, they are charged with prosecuting the crime. So they have, you know, they have lawyers, they have paralegals, they have other folks who know how to do that. So there's a handoff, and that handoff is not unique in this county. It is the norm, and it is the intentional structure of society more, you know, more generally.
If there's a failure to investigate, whose failure is it? I guess that's the question that comes to my mind. Is it does the prosecutor have supervisory authority over the investigative body? Does the prosecutor herself or himself have any independent investigative responsibility? I mean, that where the allegations relate to failure to investigate, whose failure is it? To try to say it more simply.
The prosecutor does not have the authority to act. The law enforcement does. The prosecutor does not have supervisory control over law enforcement. Again, there's a check and balance built into our society, into these structures. So if there was a failure to investigate, it would have existed within, I suppose, law enforcement in that regard. I think even some questions, you know, if I may, just with respect, oh, I forgot.
That's just because the statute says that, you know, that the reasons for recall relate to the conduct of the officer whose recall is sought. And so the question, I guess, that I'm grappling with is this failure to investigate, is that conduct of the prosecutor, or is it conduct of a sheriff or a police department? I just, you know, it seems to me a question that is raised. Is that the prosecutor's conduct?
I don't believe it is, as for the reasons detailed in the response. I don't, that is simply not, she does not have that authority. If she had wanted to investigate, she wouldn't have the staffing or the ability or the, you know, any of those
Be
things.
able to say, I want additional investigation before I consider whether this case should be prosecuted in a particular way, or whether a particular sentence would be sought. Would she not?
Yes, that's certainly part of the prosecutorial discretion to be able to look at the facts as presented and say that as part of the responsibility she has under Michigan law to look at the, you know, all of the various considerations, the crime, the defendant, prior history, the likelihood of success at trial, all of those things, and to say, you know, the facts that exist thus far with the investigations that have occurred thus far. A prosecutor, you know, not only has the ability, has the duty to examine those and to determine whether or not something's ripe or appropriate to proceed yet without further investigation.
Wouldn't the prosecutor in general be marshaling and managing the collection of evidence that she's going to present a case on?
I should acknowledge as I have not yet, I'm not a prosecutor and I never have been, but from my understanding and belief and conversations with my client, no, that's, the prosecution relies on, certainly they're building a case, but they're building a case with the evidence that comes to them from the investigations done by law enforcement.
I don't think you've answered Ms. Gerwitz's or Co-Chair Gerwitz's question. I think, and maybe you did, but I didn't hear it. Her question was, couldn't the prosecutor ask the police or the sheriffs to do more investigating, or to go further in maybe one part of a case? Or, I mean, she certainly could do that, couldn't she?
Thank you for the clarification. Could she ask? Certainly she could ask. That's not what this language says, and that's not the particular behavior that is, or failure of action that is the basis of recall as this is currently written. And that's, I think, the key to the distinction. It doesn't say she failed to ask someone else to investigate, it's just she failed to investigate.
Mhm.
And that's, you know, I'm bound as are you, as are the electors themselves with the language that, as drafted here.
So for me, it really gets to the question of, is this the prosecutor's conduct? What is the prosecutor? And I do have some understanding of who does what in a criminal case. And I think that it largely is that a case is investigated by whatever authorities, law enforcement authorities are, and then brought to the prosecutor, and the prosecutor considers the facts. And I expect the prosecutor could say there isn't enough here. Well, the prosecutor has to make a decision based upon the facts elicited during an investigation, whether to go forward with a criminal charge and what kind of charge to bring. But I'm questioning whether the prosecutor is the investigator. I think that he or she is not the investigator. So is the claim here that the prosecutor didn't require sufficient investigatory action by others? I think it may be that the asserted failure is not failure to investigate, but failure either failure on the part of others to investigate, or failure of the prosecutor to require a more detailed investigation. And I think that that's, in terms of the responsibility of a particular officer, I think we do have to know whether it's the officer's conduct, which is the subject of the recall, or whether it's really somebody else's conduct.
I had similar speculation. Just kind of practically speaking, but the speculation also then fed back to the idea like, I shouldn't have to speculate. I shouldn't have to guess. This is both trying to read this kind of practically speaking, just as a citizen in society and trying to understand, that crossed my mind. I think that I think is more appropriately a question for petitioner. But I acknowledge the question is one I had myself as I was reading this, before I had the full benefit of conversations with my counsel, or I'm sorry, with my client. And the question became itself, frankly, the very first part of the very first deficiency I noted on page 2, the overall deficiency, just kind of how many cases are involved, different dates, it goes back and forth in time, different ages, different, this, different that. Is this what they really mean? Perhaps it's, I don't know, too many questions.
I do note that you said in your position statement that where the stated reason for recall is a failure to investigate, and this would be at page 6, that you said that the use of the word fail suggests that it was a duty that was breached. And the question is, who breached that? And I guess, I keep coming at it from slightly different directions, but it's a question of whose failure is it? And what is the failure?
Do we have any more questions or comments?
Mm.
All right, thank you for
Bless
your time, sir.
Thank you very much.
Yeah, 2 folks that are representing, so I'd like to do this if it's okay with you. I have Brenda DeKuyper. That would be Brenda, and Andrea Flowers, that would be you and Mr. Flowers, okay. I have them in order here where I have Brenda DeKuyper first and Andrea Flowers second.
You can change it.
I can change the order.
Yeah.
I don't have a preference, whichever one of you two would like to come up and begin, I'm fine. And you have 5 minutes. I would ask you, before your 5 minutes starts, if you would state your name clearly and spell it for the clerk. No, you have to put it on at the base. There you go.
Hello, my name is Andrea Flowers, AndreaFlowers.
Ma'am, before you start, could you maybe pull that mic a little more center and a little more towards you? There you go.
Is this good?
Perfect.
Thank you. Thank you all for giving me time to speak today. I was not aware that I was going to be given this opportunity, so I did not prepare anything ahead of time. So I do apologize. I'm just going to be winging it here. So what brought me here is I have over 20 years, I'm a clinical social worker. I have over 20 years experience in working with victims, working within the criminal justice system as well as the correction system. So I had a little bit of experience, unfortunately, coming into this case with my granddaughter. Which brings me to the next point of the responsibility to protect. It's inherent. That is our basic responsibility to the children within our communities. Childhood sexual abuse is likely the most costly crime in society. Victims do not get to be okay. They do not get to go on with their life. They live in a world where they are constantly in fear. They live in a world where they're depending on others to stick up for them. This is a 4-year-old child. And this, unfortunately, is one case of many that were brought to my attention when I made this information public in Grand Traverse County. I provided this board with a copy of a newspaper article that illustrates several other victims of childhood sexual abuse who were given similar treatment by this prosecutor. So this is not an isolated situation. The criminal justice system and the judicial system and the corrections system are supposed to be a safety net. When bad things happen in the world, we have these processes in place to address these situations and to keep society safe. This is failing in Grand Traverse County. On June 9th, the man who abused my granddaughter and gave her a sexually transmitted disease will be released because he was given a sentence of 0 to 9 months by this prosecutor. Now keep in mind, this is just one situation. The 3 lines that were provided on this petition do not come close to providing enough room to indicate all of the problems that are occurring in Grand Traverse County at this moment. I want to kind of touch base on clarity because that's been brought up in this situation. I can assure you, everyone on this board, I can assure you that Ms. Mogenberg is very aware of which cases are listed on this petition. She has made public comment. She cannot claim that she is not aware when she has made public comment about these complaints. Going back to the responsibility to investigate. Only Ms. Mogenberg was able to order additional testing. Only her. You cannot call the sheriff's department and say, here, I need you to call the jail and order more testing for this offender. It's not going to happen. That had to come from Ms. Mogenberg's office. She failed to do that. Now, whether we want to split hairs on the verbiage, that's up to you folks. But she was very aware. She was aware that the testing did not cover the specific strain, and she failed to order additional testing. She was made aware of a video. The sheriff's department didn't want to touch it. So yes, we went that route. The sheriff's department didn't want to touch it. Protective services didn't want to touch it. We took it to Ms. Mogenberg. It was her responsibility to call the sheriff's department and say, pick up this computer and investigate it. She failed. Now, again, if we want to look at verbiage, I understand that that is why we're here. But if we are looking at the spirit of this petition and the spirit of these complaints, it is very clear that she has failed her constituents. It is very clear that she is failing the children of Grand Traverse County. This is unacceptable. Society will never be made safer by a weak prosecution. And the pace in which she is dismissing these cases or pleading them down to next to nothing. So we have offenders back out on the street who are going to hurt more children. This is unacceptable. The recourse that we have is this petition. The recourse we have is to give the constituents the ability to use their voice. So I'm asking this board to look at the spirit of these complaints and to give us the green light to go ahead and right this wrong. Thank you.
Would you stay for questions?
Certainly.
I'd like to just lead on the questions for a minute. I have a couple questions for you. Number one, are all of these references to medical tests and children under 4 and children under 13, are these all related to one particular case?
Yes, and the reason I used that particular language is because that is how it is written in the law. The defendant had a victim under 13.
Okay, so
That is
this all
how it is
relates
written
to
in the
one
law.
case.
Pardon?
This all relates to one case.
Correct.
So in this recall petition, we have two cases. We have a motorist and we have a motor vehicle accident and we have this unfortunate incident with the
Correct.
child. Okay, just for clarity. Second question for you though is, you're a social worker, right?
Yes.
So you've seen prosecutions of these things before. Are you involved in that on a regular basis?
I was employed by the state working high secure juvenile, and half of my caseload was sex offenders who unfortunately are also victims.
When
So
your
yes,
experience is part of the standard practice of prosecuting an assault like this, of this nature, is part of that standard practice to go through and look at evidence maybe that's still out there that has to be pulled in, as in the video, or to go through a standard list and say, here's a group of medical evidence that we need to gather. That's not just off the top, right? Is that kind of a checklist item?
So from my understanding, and I would have to refresh myself in looking at the law, but Michigan Crime Victims' Rights Act requires that victims or that offenders be tested if they have committed a sexual offense. That offenders be tested very early on in the process. I had never seen a situation where an offender was not tested immediately. In fact, my daughter had to, when my granddaughter was diagnosed, my daughter had to fight to even get one round of testing done. So yes, to answer your question, it is standard that additional evidence be gathered and taken to the prosecutor for the review. And then obviously the prosecutor has the ability to go back to the investigators and say, I need more evidence. I need you to look at this computer now that I have, now that I have more evidence, or now that this child has disclosed, I need you to go back and do some additional work. In my opinion, that's just doing a thorough job.
Isn't the making of a video and even possessing a video like that correct? I'm not an attorney. Isn't the making and possessing of a video like that a crime?
Absolutely.
Prosecutable in its own right?
Yes.
So the awareness of that, was that part of this package?
Yes.
Prosecuting for that video?
Yes. She was made aware on August 4th that this video, that the child had disclosed that this video was made. And I have a letter on, if you would like me to dig it out, it's where Ms. Mogenberg acknowledged that, she was in receipt of that information, but obviously chose to do nothing with it.
Thank you. Thank you. I kind of stepped in front of you, folks.
That's all right. First of all, Ms. Flowers, I want to say I'm very sorry about your grandchild, that this is, it's hard to read, it's devastating. And on that note, I want to be very clear that if we deny the petition today, that doesn't mean we're saying we don't think there's any merit to the petition. It just means it doesn't follow the guidelines that we have to uphold and the statutory law that we have to uphold. And in the end, for your position, you're going to want it to be as clear as possible so that you get the signatures you want. You don't want people reading it and not understanding. And maybe people in the county understand much better than we do. But I just want to be clear that whatever we decide today is not on the merits of your position.
Thank you.
Whether the prosecutor should be recalled or not. It's that the petition as it is right now doesn't follow the guidelines that we have been sworn to uphold. I just want to be clear about that.
Thank you.
So I have a question about the sequence of events, because there are a number of dates set
Mhm.
forth. And so there's a failure to consult with the victim regarding a plea on June 13th. And then there's failure to investigate allegations made on August 25th.
Mhm.
So there was a plea and then a separate allegation which did not relate to that plea, but to something else.
Correct. So the plea was accepted on, I believe, June 13th, 2025. And then in August, early in August, the child disclosed that a video was made.
Okay, so the
Sentence, I'm
plea
sorry, go
was-
ahead.
The plea was accepted on June 13th,
Correct.
and then another allegation against this, the offender was made subsequent to the plea. Is that right?
Correct. And
And that-
sentencing,
Would that have been a separate offense that wasn't investigated?
it would have been a separate offense, yes. Well, it could have been. It depends on how they wanted to handle it at that point. When I called the sheriff's department regarding the video, they told me that they were going to add it to the bottom of the original complaint. So the original complaint listing all of the abuse, they were going to add it to that complaint. So they could have done an entirely different complaint, or I guess they had the ability to add it onto the bottom of the current one.
But there was already a plea accepted,
Correct.
so it couldn't have been added because the complaint would have been resolved.
That was prior to sentencing. So my understanding is that plea could have been withdrawn and further investigation could have been done.
Yeah. Which, it's complicated, obviously. Which is what we're grappling with here, trying to understand what the conduct of the prosecutor, what is the prosecutor's conduct that is the subject of the complaint. Okay.
Any further questions?
Mr. Cordes? Thank you for your time.
Well, again, thank you for
Thank you.
giving me the opportunity to speak.
Thank you. You were, without preparation, you were very eloquent and
Thank you.
Good morning. Before you start your 5 minutes, would you state your name and spell it?
Yes, sir. Brenda DeKuyper, Brenda, DeKuyper, DeKuiper. Thank you for allowing us to be here and to have the opportunity to,
can
To
you speak
speak.
a little closer to the mic?
yes. That better?
Yeah.
Okay.
I'm sorry.
Thank you for giving us the opportunity to be here and speak. I'm not an attorney. I don't have any fancy words, but I'm going to probably end up talking fast because I want to get through everything that I would like you to hear. So forgive me if I talk too fast and you can clarify anything afterwards. How's that? The job of the prosecuting attorney is they are responsible for reviewing evidence from police, filing criminal charges, conducting trials, conducting plea negotiations, and advocating for victims. Prosecutors are considered ministers of justice. rather than advocates, focusing on upholding the law and protecting community safety. They act in the public interest, handling cases from the initial charges through sentencing. Initially, they evaluate police reports and evidence to determine if there is probable cause and sufficient proof to file criminal charges. In our first meeting with Ms. Mokenberg, we asked if she had read through the police report. Her response was no. But if it goes to trial, I will know it inside and out. We said he intentionally crossed double yellow lines at the crest of a blind hill. He broke the law. That is in the police report. In fact, a passenger in the truck that killed our son stated the driver was upset and frustrated because a car had passed him and he was going to pass the car back. That could have been thought to be road rage, which is what another witness in the police report stated. Instead, Ms. Mokenberg's response to us was, I drive Supply Road and see people passing on the double yellow all the time. So by law, her job is to uphold the laws, but instead she condones the breaking of the law because everybody does it. When Ms. Mokenberg and one of her assistants went out to the crash site, she said both said instantly it was the felony charge of reckless driving. Then there's the victim consultation and rights. In nearly all jurisdictions, laws and amendments mandate that prosecutors protect the rights of crime victims. Crime victims. Before making a plea offer, the prosecutor must make reasonable efforts to confer with the victim regarding the proposed terms, notify the victim of scheduled plea hearings, and inform the court of the victim's position regarding the agreement. First off, Ms. Mokenberg made no effort to consult with us, the victims. We were totally blindsided by the plea deal she was going to offer. I, in fact, was so mad and upset, I had to walk out of the room, and I screamed. Noelle made the comment to those left in the room, I guess she's upset. And one of the ladies, Lisa Skirmahorn, that was in the room, said, you're damn right, excuse my language. She has every reason to be upset. To consult or confer means to seek advice, information, or guidance from an expert. It also refers to the act deliberating with others before making a decision. We were not consulted at all. She came in the room and said, this is what I am going to offer him. We said, if you want to remove something, remove the 4 counts of reckless driving causing serious impairment of a body function. But you leave the death charge in there. We said he needs to have Sam's death on his record. The original charges were 1 count reckless driving causing death and 4 counts of reckless driving causing serious impairment of a body function, which were all appropriate charges for the actions and results of that day. She'd offered him a plea deal of 2 counts reckless driving causing serious impairment of a body function. We said, how do you remove the most serious part of this whole case? How do you remove the innocent life that was lost? I stated that Sam is not an injury. He is not at home and he is not at work. He is dead. So if you do not charge the person who by breaking the law took our son's life, then where is my son? What happened to him? Would you like me to continue?
Keep going.
She said, 1 life has been ruined. I don't see the need to ruin another life. Sam's life is not ruined, it's gone. Hundreds of lives were ruined by that Mr. Schramm's actions that day. Mr. Brady states that plea seemed reasonable given the defendant's history and the offense, the likelihood of conviction at trial, and the wishes of the family. Number 1, the defendant had a history of driving fast. Someone stated That kind of driving was a way of life for him. People told him he better knock it off or he is going to kill someone, himself or someone else. And here we are. Secondly, he broke the law. There was no question whatsoever that he passed on the double yellow line and killed an innocent person. The likelihood of conviction at trial was extremely strong. We also said we would prefer to have a jury make that decision rather than one person determining the outcome. We were willing to take that chance. Thirdly, the wishes of what family said that they approved that. We were so appalled at this plea offer, we asked her several times, as I sent you several letters that were sent to her and another judge. Plea offer, which is she continually said no. Probably the wishes of the defendant's family, I would imagine, considering she had more excuses for him and defending him more than the innocent victim she was supposed to be representing or the law she was supposed to be upholding. It was not a savvy move that Noel Mokenberg made to have the defendant admit that his reckless driving caused the death of Sam DeKuyper. The defendant's attorney asked him if by him taking his eyes off the road and veering into the other lane of traffic, he caused the death of Sam DeKuyper. The defendant simply said yes. That's all he had to say. He never said Sam's name at all, never had to admit himself saying the words. He said yes. Sam's death is not on his record. I have that right here. So he never even said Sam's name. Sam's death is not on his record. If he causes another crash and takes another innocent life, it will not show that he took a life already. His record states 2 reckless driving causing death or causing serious impairment of a body function. No death. If you want to find the death of our son, you have to dig deep into his record. That's the only way you're going to see that he caused our son's death. It is simply a cop-out on Ms. Mogerberg, and she felt she could pacify us and the community with that. Our son was so well known in Traverse City, you would be amazed at everything that people have done for him in his name. She knew that the community would not satisfy the community. Time and time again, we told Noel that the big thing for us was not about the time that he was going to have to serve, but it was that he was held accountable for Sam's death. That is what was, that it was on his record that he took Sam's life. Because if it does not show that he took Sam's life, it's not on the record. Can you tell me where my son is? He did not take his own life and he did not die of natural causes. His life was taken by the driver of that truck, Mr. Schramm. We asked if she wanted to make a plea deal, then offered to remove the 4 counts of reckless driving causing serious impairment of a body function, charge him with 1 count of reckless driving causing death, and leave the sentencing up to the judge. Whatever that is, whatever that looks like. We felt that was more than a fair compromise, considering the likelihood of him being charged had it gone to trial. With the evidence in the police report and the witnesses, I would say it was highly likely. We said to Noel, he made a conscious choice to pass where he did and when he did, with nothing impairing his judgment. You know what she said to us? He wasn't thinking. He wasn't thinking. That's what she told us. Her excuse for the driver of the truck for taking an innocent life, he wasn't thinking. That's why he passed on the double yellow line at the crest of a blind hill, because he wasn't thinking. So if you were to cause a crash and kill an innocent person, you can just tell the officer, well, it's okay because I wasn't thinking. Just go talk to the prosecutor. She says it's okay. You take someone's life because you weren't thinking at the time. She would be better served as a defense attorney rather than a prosecuting attorney. We asked if we could get our own attorney rather than have her, because at least we would have had someone fighting for our son rather than somebody protecting the person who committed the crime and not standing up for the innocent victim in so many cases. The facts are, the fact is Noelle Mockenberg failed to investigate. Read the police report. She told us she didn't, but she would if it went to trial. She said they are busy and don't have time to read through it all unless it goes to trial. The fact is she did not consult with us about the plea deal. All the letters we sent are proof of that. She came in and told us what she was going to offer for the plea deal. And that was the end of it. No consulting, no talking about it, no compromise, just that is it, period. The fact is the original charges Ms. Mockenberg brought against the driver of the truck were 1 count reckless driving causing death and 4 counts reckless driving causing serious impairment of a body function. The fact is she gave him a plea deal of just 2 counts of reckless driving causing serious impairment of a body function. And that is what is on his record. She eliminated the death of the innocent person, our son, Sam. Those are the facts. Do you have any questions
We
for me?
have questions. Before we have those questions, please accept the sympathy and the condolences and the heartfelt of this board.
Appreciate that. Thank you very much.
Ms. Cummings.
I hate to have you go through a couple things, but when you say she failed to consult regarding the plea, so can you, I know you touched on it, she had a meeting with you and your family and came in and basically just told you what she was gonna do, is that?
Yes, we came in the room, we sat down, she said, okay, this is the plea offer that I'm offering him. And as I said, I had to walk out of the room. There was no saying, okay, what about this? We then, after she tried saying, okay, well, what about this or what about that? And we several times said, it's not about the time. She did not want him to have to go to prison for what he did, for taking Sam's life. She told us that. She did not feel he should have to serve time in prison for what he did.
Did you meet with her before? Like, how many meetings did you have with her, with the family?
We had a total of 3. The
Okay.
first one, the second one was when she gave us the plea deal, when she told us the plea deal she was going to offer. That was the second meeting. The third meeting was for, I want to say the restitution was the third meeting, dealing with restitution stuff after the sentencing.
And in the first meeting, did she give any indication of which route she was going as far as prosecuting?
We thought by everything she talked about, she said, when they went to the crash site, it was instantly, without question, that it was the felony charge of reckless driving. Because, if you see where it happened, and by the police report, if you read that police report, you know that it's like there's no question. There was witnesses that saw what happened. There were witnesses that's seen him passing another vehicle. There's 2 of them that in the information I had sent you from the police report. If she had looked at, every indication we had, we walked out of the meeting thinking, okay, she's going to go for this. And then totally blindsided us with this plea deal a matter of weeks later. It just totally shocked all of us. When we would tell anybody, it's like, nobody can believe that she would offer it. Like I said, we said, take the 4 counts of the injury out, but you leave the death in there. And it didn't matter to us. If he served 6 months, then he served 6 months, but it was on his record that he took Sam's life. Because right now, there's no record saying anybody took his life. So what happened to him? Where is he? And actually, I've been talking with Representative Roth, and he is working to see what we can do about changing that law, that if somebody is charged with reckless driving causing death, they cannot plead that death out of there. That death has to stay. They can plead the sentencing, the time frame, but that the death needs to stay in there because that needs to be on the record.
Thank you.
You're welcome.
Vice Chair.
I don't think it's relevant, but did you say he only got 6 months?
No, he ended up getting 2 years. 2 years, and he is currently serving still at, was it Jackson, where they all of them go to get evaluated and then they get dispersed to different prisons from there. He is currently still at the incoming in the hospital ward part, serving basically in a hospital setting. He is not serving in a jail cell. He is not in general population. He is simply in an ER room.
It's a heartbreaking experience for us.
Yeah.
We've considered a lot of recall petitions, but this is the most painful, both with regard to Ms. Fowler's granddaughter and your son.
Eh,
Um,
As Andrea alluded
Heather and I
to,
both have sons.
Oh.
We're crying here. No, I don't mean to diminish. I mean, it's very painful and
it is,
and
it
the,
is.
the standards that we are required to apply
Yep.
when considering a recall petition, they don't really take into account the emotional reaction, I suppose. I'm not sure if I'm saying that right, but
Well, and as Andrea stated that, I mean, with all the people that have come out, we could fill probably 5 or more pages of similar situations.
Other questions?
I do have one, and I'm not sure if you can answer this. Do we know the prosecutor's current term, when she?
It's the same as the presidential.
Okay.
So you can't recall somebody in the first year or the last year of their term. So we were working on doing this as soon as possible because, we had somebody that said, well, why don't you just wait and not, have somebody run against her in the next election? And it's like, well, that means there's 2.5 to 3 years left where she can do this to other families. And no other family should have to go through what we've gone through.
I have a couple questions for you.
Yes.
The standard the line that we have to tread here
Mhm.
involves, is the statement factual? Are the reasons for recall factual? Well, I think we're past that. The other one is clarity. Do both the prosecutor and the voters of Grand Traverse County who would be signing your petition have the ability to read your material and be clear as to the facts and what's involved? So with that in mind, when your son passed away, was this covered in the media in Grand Traverse? This was in the newspaper?
There
radio?
were so many articles done on our
Anybody
son
reading
and
this would have
and
they
his
would have
death.
no problem tying this to.
Oh my gosh, let me, okay, so Sam was very well known. And that's why there were so many articles done in the paper on him and everything that has been done for him after his passing. He was 22 years old. And keep in mind, I'd like you to think about you now. What would your processional look like now? Sam's processional from the church to the cemetery, 53 cars and a packed charter bus, 7 police cars, only 3 of which were on duty. The other 4 were there because it was for Sam. There were 2 fire stations with their lights on and trucks and ambulances blocking intersections. There was 2 conservation officers standing at attention at the state park as Sam went by. 22 years old, there were over 1,000 people at his memorial service, 600 to 700 the night before. That is how well known Sam was. So if you did not know Sam, you knew somebody who did know Sam. That is the outstretch that this impacted. It still blows me away, the impact that he had on the community. He went to Traverse City West, so people knowing about this, you'll be hard pressed to find somebody that is not aware of this case and who Sam was and what happened.
Ordis.
Thank you.
Thank you for taking the time to come, and thank you for taking the time to tell us.
Well, appreciate you being here, and I know you have a very tough job. I worked as a deputy clerk for a few years. I can totally understand and appreciate what you have to do. So thank you for your time today.
Thank you so much.
Thank you.
Okay. We have some. Pardon me? Are we ready to make a motion, or do we have thoughts we want to share here to you?
This is certainly the most difficult recall petition that I can recall. This is my 5th year on the board. I would have phrased it differently. If I were writing a recall petition, I might have, because I'm not sure, as my questions indicated, whether the complaint about the prosecutor is that she acted without sufficient investigatory information, as opposed to failing to investigate, but
I don't mind jumping in. I think I guess I reject the notion that the proper legalese must be used in one of these things to make it clear. In fact, legalese would probably make this less clear. I think that most people understand that there is a relationship between law enforcement and the prosecutor, and in many instances, a prosecutor, judge, may have to request additional information as part of an investigation. So the word investigate to me does not gum up the clarity here. In my mind, given the questions, if that's what we're getting hung up on, I guess I don't see the use of the word investigate as something that is making this less clear. And I find that the factual basis of everything here has been sufficiently taken care of in my mind, given the comments of the petitioners. So that would be my only 2 comments.
I appreciate the fact that that maybe looking at the legalese makes it less, that it's an attorney's way of looking at, but that's not what we're doing, right? We're looking at what somebody who was asked to sign the petition would understand. And I think that's really a point very well taken.
But, I mean, to argue, the other side is some of this was clarified today because we were allowed to ask questions of the people who wrote this, and that would not be the case for people signing. And I mean, I have to admit, and again, I don't live in the county, the sentences about Miss Flowers' granddaughter, I was thinking it was more than one case. And maybe that doesn't make a difference, but it certainly falls in the category of not being clear to me. But I want to hear, I'm not saying you have to respond to me, but I want to get your thoughts on having those 5, let me see, like how many, I would say starting, so 1, 2, 3, like the last 3 sentences are regarding Sam's tragedy. And then the ones above are regarding the child's tragedy. The ones above are kind of seem convoluted to me. It seems like it could be more than one case. It wasn't clear to me at all when I was reading it.
Let me ask a question, Ms. Cummings. So, and this, I'm not sure I know the answer to this either, but if the wording here on this petition was clearly broken into 2 sections, and the first section started out with the name of the case for Ms. Flowers' granddaughter, it would start out with the name of the case of the defendant, apparently. And if the second case stated Sam's name in the case of, would we look at that as a?
Well, so I did ask myself the question, what would make it clear? I do think looking at other petitions that we have approved before, we have looked at it being unclear if there weren't a date or something that designates what it is we're talking about. So yes, I think if it had, even if it had the name of the parties and the year, that would be more clear. And to me, it looked like there were more than one case. Even if it said one case, which included, listed it out. I mean, and let me be clear about why I would be arguing for this is also to ensure that it works well for the drafters of the petition, which is what we're all hoping for, right? That people can look at this and understand what's happening. I do admit that maybe in your community, everyone knows what you're referring to. And that might be my, it's not ignorance, but that might be me looking at this thinking, I don't know what's going on here, but is that okay based on what we are here to do to make sure that everything is factual and clear? I think that behooves us to not make assumptions about what's being talked about.
And just for the record here too, we've had in the past people who have come to us with petitions where there was questionable wording or where there was questionable clarity or factual statements. And the beauty of the Board of Canvassers is this isn't once you have your turn, you never get to come back. The Board of Canvassers meets again actually in a week, and we meet in June and we meet in July. That's why I'm asking questions about how would this work. So if these 2 cases were,
Right.
these 2 cases reflected what was on the court docket, right? There had to be a case, not a case number now, but a case name for the perpetrator that harmed your granddaughter. There would be his name would be on there. Your granddaughter's name can't be on here. In Sam's case, there would have been something that would have gone to the court that would have charged the man that killed your grandson. And that would be on, that would be a matter of court record. You have it. And so if,
I would say something, I'm not necessarily, saying I fully agree with this, but even if you had something as simple as case one, and then
Yeah.
once it goes to the second one, case two, there is also a clerical error on here where, the prosecutor's name is spelled incorrectly, once in the petition. I don't know if that's particularly relevant. I think everyone knows who we're talking about, but.
are we providing clarity?
Are we rewriting the petition?
We have to be careful. We can't we
Right.
can't rewrite
But-
this for you.
No,
But it does, the questions that I've asked, I think, that it seems to me that the complaint is about a failure, or it's about acting without sufficient investigation. At least with regard to the child sexual abuse. That there were, and that's what each of these says, failed to investigate, but it's really reaching a plea deal without an adequate investigation of the charges. Is that what it seems like to you? And I agree with Member Cummings that the way it was written, I thought that it was several different cases, not a single case with regard to the child abuse.
yeah, I think the fact that we had to ask these questions is proof of it being confusing. I mean, it almost is the definition of clarity. But again, I say that, I think where you're from, everyone knows what this means. You can respond. Is that okay? Or
um,
I'm acting as chair all of a sudden. Yeah,
if this were to be,
right.
if this were to be reworded and resubmitted, and it had the names of the cases. Um, that's actually, I'm not sure if you would name the plaintiff or the victims here. You can't name the victim. You're naming the court cases, naming what was brought to court, the way it appeared on the court calendar would certainly fulfill the clarity. I think, I'm speaking only for myself, but that would be crystal clear on the clarity.
I would disagree. I mean, I think really what we're getting at here is not even necessarily the case number, but just specifying this is case one, this is case two.
I agree.
I
Yeah,
don't even think you necessarily need like the details of the case, like literally just saying, this is case one and here's what happened. And this is case two and this is what happened. Like, I think literally just having those words inserted would clarify that you're talking about case one, all of these things happen. Case two,
Mhm.
all of these things happen. You could put in the additional details that I don't think hurt, but I think that making that as a clarifying factor would probably alleviate
agree.
a lot of the concerns.
I agree with that.
With regard to the factual, I have no problem agreeing to that. I would see that this lays out a prosecutor who had the responsibility to make sure she had the materials and to request the items that are listed here as part of the duty to prosecute a case. Again, I'm not speaking as an attorney.
Well, we know that. You
Okay,
don't-
I'm sorry.
I
You don't-
think Paula suggested that
Yeah.
speaking or thinking as an attorney is an impediment.
Yeah, well, yeah.
Right.
Ms.
So
Cummings and I are both attorneys, neither of them are. So,
we were kind of leading that way, yes. If there isn't any more discussion, I would ask that we have a motion one way or the other here.
Sorry, I know we're all. I'm not in either. Sorry. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Brenda D. Kuiper against Grand Traverse County Prosecuting Attorney Noel Mogenberg on May 11th, 2026 are not factual and sufficiently clear because it doesn't indicate there are two separate cases. I don't know if that's, I guess we didn't discuss what the reasons would.
Director Prater, would you like to advise us on how that motion should be worded?
I think as best you can as a board, agree on the reasons that you are not finding the language to be sufficiently clear. Would be helpful for all the other parties. So presumably if they're going to resubmit, it would be helpful for them to know specifically why you did not find it sufficiently clear.
So, Paul, do you agree?
Yeah, I think the, the only thing I find, as a compelling argument as to why this would be unclear is that first, is that the, in regards to the sexual abuse of the minor, that entirety of that case, that it is not clear that that is all one case. I mean, that I think is what is probably the most confusing portion of this. So if I were to have to articulate that, I would say not sufficiently clear due to, you know, the case, a case not being, or
No, I'm trying to think of the word.
What if you say, if it's not clear in, with regard to the number of incidents involved
sure,
and the identification of those
number of cases involved.
Number of cases.
cases involved?
Okay. Are you guys
I
good
would
with?
still, in the motion, I would still put, just for going forward, I would still put in the identification of those cases.
Okay. Are you good with that? Karen?
Yes.
Okay. Am I allowed to redo the motion?
Sure.
Okay, thank you. Thank you, Chair.
You're welcome.
I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Brenda D. Kuiper against Grand Traverse County Prosecuting Attorney Noel Mogenberg on May 11th, 2026 are not factual and sufficiently clear because the number of cases were not clear and the incidents. Sorry. Because the correct number of cases were not clear and the cases themselves were not identified.
Second.
It's been moved and it's been seconded. All in favor?
Aye.
Aye. And it passes. The motion passes. We did everything we could to try to help you sort out the fact that we'll probably see you again. Like soon.
We do.
Just to clarify, just under the law, just when recall language is submitted, the board has to meet between the 10th and 20th day after
Oh.
the submission. So there's no way they would be taken up next week because that's less than 7 days. But for example, if it were submitted on June 1st, the board would have to meet between June 11th and June 21st to consider that language.
What's our June meeting? Sorry.
I don't know the exact date, but sometimes we have to reschedule it because there's that 10-day So we may have a scheduled meeting in June, but regardless of when it's scheduled, it would have to meet within the 10-day window to cover the recall language.
We have 2 meetings scheduled in June currently, is that correct?
Yeah, I think so. I think one of them was in the event, oh, we only have one. I think
Yeah.
we scheduled that in the event that the board might need to reconvene if there's any litigation.
That was the one on
involving
the
the decisions, but that's a notice meeting, so we wouldn't have to renotice it if we were gonna meet on that date. If we're gonna meet on a different date, we would probably cancel that meeting and then reschedule for another date.
What is the normal board meeting? What is the standard board meeting in June? What is the date?
June 5th,
June, that is June
June
5th?
5, yeah.
Okay. And we have a second one kind of tentatively.
No,
So the next one that's regularly noticed is July 31st. So the board can always meet at other dates, but we just have to specially notice those meetings. And that often happens with recalls because of the strict 10-day window that the board has to meet.
So if you look on our website, all of our dates all of our meeting dates are listed. June 5th is listed on there, the meetings in July. And if you have trouble with those dates, I would urge you to reach out to the Bureau of Elections. Okay. So we have a tentative meeting June 5th.
For example, in order for the board to consider recall language on June 5th at that meeting, it would have to be submitted by tomorrow? Okay, by tomorrow. Or if it were submitted later, the board would schedule a different meeting date.
Okay, but the board was
So
still.
it wouldn't be the case that, like, if they submit language in a week, we wouldn't be waiting till July 31st. We would schedule another meeting to consider it.
Does that give you some answers?
We would have to have a hard copy by tomorrow. But again, just to clarify, the meeting is scheduled based on when we receive the language. So we already have, it's not the case that something has to be submitted by tomorrow to be considered. It's just for it to happen on June 5th. That's what would have to happen.
When you submit it, it will start the clock on when we need to call a meeting to hear your submission. We can't give you a guarantee in advance, but we kind of drew a picture. Yeah. Well, thank you very much, and thank you for being here. If you have questions afterward, we'll be around. Customer service.
Take a break.
Okay. Can we move forward? Do you need to take a break? Okay. We're going to break for 10 minutes. We will, we'll come back here at 10 minutes to 11. We are back. Next item on the agenda is the consideration of the sufficiency of the nominating petitions submitted by Philip Tanis for the office of U.S. Representative, 4th District. Mr. Ziegler, would you please state your name and spell it for the clerk after you turn the microphone on. There you go.
Thank you, Chair Housecamp. Good morning. My name is Dan Ziegler, Ziegler, from the law firm Dickinson Wright. I am appearing on behalf of the Kalamazoo County Republican Committee in its challenge to the nominating petition submitted by Philip Tanis. Mr. Tanis did not submit 1,000 valid signatures, so this board should reject his petition to be placed upon the August primary ballot. Now, after the Bureau of Elections reviewed the sufficiency of Mr. Tanis's petition, they determined that there were 1,331 valid signatures. But the Bureau of Elections made two errors in its calculations. First, the Bureau erred in concluding that circulators do not need to write their state when they are writing their residence address. The Bureau's recommendation on that point runs headlong into the Court of Appeals case Wickman and into the Secretary of State's guidance on this issue. Starting with the guidance, the Secretary of State issues a petition manual titled Nominating Petitions for Partisan State and Federal Offices. Page 24 to 25 of that manual describe defects with circulator certificates that will invalidate an entire petition.
Mr. Ziegler, would you mind if I interrupt you for 1 second? I did not, I'm afraid I failed to ask Director Brader to read the staff report on this item. So if you could, just mic
Of course,
down,
Chair.
and we'll let Director Brader read it, and then we'll pick up exactly where we left off.
Sounds good, Chair Housecamp.
Director Brader, my apologies, and
No problem. No problem. Sorry, I apologize for the breaking off your presentation there. So this was the first of several nominating petitions that the board is considering today. So in our review of this filing, which is for U.S. Representative in Congress, 4th District for the Republican primary, there were a total of 1,508 signatures filed. We initially determined that 177 of those were invalid. The primary reason being that there was a required element on the nominating petition form that was missing. So based on our review, that would leave 1,331 valid signatures prior to the challenge, which would leave the candidate with a cushion of 331 above the minimum 1,000 threshold. The primary required element that was missing was the petition was cut off. Some of the language was cut off at the top in copying, so just full words and letters were not appearing as required. So then we did receive a challenge, as we started to hear about. We'll hear about more. That was challenging 597 of the signatures. And of the 597, there were 177 that overlapped with signatures that we had already disqualified. So there was no need to consider those challenges because we had already determined separately that those were not valid. But there were still 420 left, which would, if all those were accepted, would put the candidate under 1,000. So we considered the challenge there. As council was beginning to get into one of the issues here involved the circulator writing their city or township of residence in the circulator box, and whether that the failure to include the city or township of residence would disqualify all the petitions on the sheet, essentially. And the question is how this case, Wickman, which involved the city or township of the circulator, would apply to this situation. So Wickman involved a case involving like a local zoning petition, ballot petition, and was bringing in the requirements through statute of 544C, which also applies to nominating petitions. And in that case, the court found that the circulator who included in the city or township box their address in a village, in the village of Vulcan in that case, the court determined that that did not meet the city or township requirement. The way that we understand that, BOE staff understands that to apply, is that if you do not put if you do not put your city or township on there, i.e. in this case, if you put a village, that does not comply with the statutory requirement. In this case, there were circulators that put city or township, they put a city or township in residence, but it was, in some cases, the post office city or township, but they're mailing, essentially their mailing residential address format, city or township, rather than the election jurisdiction city or township. We didn't, so that's different from the Wickman case in which somebody did not put a city or township at all, they put a village. So we did not interpret that as meaning that that situation would result in those signatures getting disqualified. So I think that was the primary point of disagreement with the challenge, but we can hear more obviously from the challenger on that. And then regarding the state, you know, in this case, these were individuals that had put information elsewhere in the circulator box that clearly indicated that they were within Michigan. On that basis, we didn't think that the statute required disqualification because they didn't separately write Michigan when they were in state and had put other information that indicated Michigan residency. So those are sort of the primary legal points of dispute from staff's perspective, but based on the way that we determined those issues regarding the city or township in the circulator box and the state, which are really the signatures that would determine, I think, whether the candidate has enough, we determined that those challenges were rejected and that the candidate would be left with a sufficient number of valid signatures.
Thank you, Director. Mr. Ziegler.
Chair Hauskamp and the board. So a point of clarification, I think that's important, is the applicability and what Wickman says and matters about. So Wickman is important to this case, but it's not actually the most important authority in this case. Wickman primarily stands for the proposition that the elements of a circulator certificate must be strictly construed against the circulator, that the circulator has to fulfill out every painstaking element of that certificate unless the law specifically creates an exemption. But Wickman's not the most important thing here. What's the most important thing here is the Secretary of State's manual, which interprets the law and applies it. And on pages 24 and 25 of the manual, the Secretary lays out what defects in the certificate of a circulator will nullify entire sheets, make them invalid. And the Secretary writes that a petition sheet is invalid if it contains one or more of the following defects in the circulator certificate. And she says the circulator's residence address is omitted or incomplete. According to the United States Postal Service's Domestic Mail Manual, which is a 1,600-page document describing all things about residences and addresses in the United States, all mail must bear a delivery address that contains at least the city and the state or state abbreviation. So the issue is that without the state included in the circulator's certificate, the circulator has not completed or provided a complete circulator's residence address as required by statute and the Secretary of State's guidance. So under that standard, an additional 16 sheets and 158 signatures are invalid. An additional error, the second error, that was the first, the second error created by the Bureau of Elections is their conclusion that circulators who wrote down Holland instead of their residence address, instead of their physical address, which is Park Township, had written down their address for purposes of Michigan election law. The problem with that is that circulators who wrote down Park Township didn't write down their residence address as that term is defined by Michigan election law. MCL 168.11 defines the term residence for matters of Michigan election law. And it holds that a residence is where a person habitually sleeps, keeps his or her personal effects, and has a regular place of lodging. So simply as used in Michigan election law, a residence is about physical location, not about mailing norms. Consider this. If a person lives in Holland City and has a Holland City mailing address, can they vote on a Park Township zoning ordinance? The answer is clearly no. But if a person lives in Park Township and has a Holland City mailing address, they can vote on Park Township zoning ordinances. That means, consistent with MCL 168.11, residence as used in election law is about physical location, not about mailing address. So in this case, where certain circulators on 22 sheets totaling 175 signatures wrote down their mailing address, which was Holland City, which is in Michigan's 4th District, but actually resided in Park Township, they did not write down their residence as that term is defined in Michigan election law. Therefore, those signatures and those sheets should be thrown out. All told, the Bureau thus overcounted the number of valid signatures on Mr. Tanis's petition sheets by at least 333, 158 under the first challenge, 175 under the second challenge, which means Mr. Tanis only has 998 valid signatures, and the board should thus vote to keep him off the August primary election. Thank you, and if you have any questions, I'd be delighted to try to answer them.
Mr. Cordes, have you got a question?
So you're not challenging the validity of the signatures from the voters who signed those pages, just the circulator itself?
Yes, and under the statute MCL 168.544C and the Secretary's guidance, if there's an error with the circulator certificate, the whole sheet is invalid, even if all of the
No,
individual.
I understand that. I
Yeah.
understand that. I understand that. Yeah. That's it.
Mr. Gerwitz.
So would you clarify again? So the circulator certificate requires the person's residence address
So the circulator,
city or township. Wait, tell me again what it says. I'm not looking at it.
so the circulator certificate requires various identifying information
Right.
about the circulator to include a complete residence address. And that term is not defined specifically in Michigan election law. It's used generally. So turning to the United States Postal Service for a definition of what a residence address is, you see that a residence address includes a state, which is consistent with the statutory language, which says the circulator must include a complete residence address, and then says in a parenthetical, street and number do not enter post office, city or township, state, and zip code. So by statute, the Secretary's guidance, and a common definition of address, state is required.
Fire question?
I mean, we've had this confusion before with regard to post office and residence addresses. My residence address is different from my post office address. And I get mail to both Detroit and Highland Park because my post office is in Highland Park, but my residence is in Detroit. And that kind of confusion, I think, is what the staff attempts to resolve with regard to what is required. I don't have questions. Do you have any? No.
Did you submit, I'm not chastising you here. Did you submit a letter?
I did not know.
Okay, all right. I thought I missed something and
My client submitted a challenge,
Okay.
and these issues were raised in that, but perhaps not with sufficient
no,
clarity.
that's good. Can you just reiterate how many votes you're saying were incorrectly?
At least 333. So the Bureau of Elections, because they determined that the remaining sufficient challenges would not bring him below 1,000,
Right.
did not consider many of the challenges. But in these two categories, it is 333 signatures that would be invalidated. And I think, just to clarify, the strict standard of writing down the complete address and knowing the distinction between mailing and physical only applies to the circulator. There's a lower standard for actual signers,
And you're strictly addressing the circulators.
just the circulators.
Director Brader, do you have anything to add from the Bureau standpoint?
Well, I mean, I certainly agree that there is a different statutory provision when it comes to the signers. That's true. I think this issue, to my knowledge, at least with regard to the circulator jurisdiction and state, has not been raised. Maybe I'm wrong about that. This is the first time we've gotten this kind of, so we don't necessarily have past rounds of election cycles to evaluate this. In looking at the statute, it says residence address. It's also, the statute also lays out an address block essentially. So it's got a line for complete residence address, street and number or rural route. Do not enter a post office box. And then it says city or township, state, zip code. There's a line for that. This is all in statute, right? So this is what the statute does. It generally looks like the kind of thing where you generally put your mailing address format. I mean, you certainly could know that you would put your voting jurisdiction there. That's definitely something that someone could interpret or understand that as being, but it's also looks like something where you would put your mailing jurisdiction. So with that sort of the language in the statute as it is, as we understand it, and with the Wickman case interpreting this language, but in the context of someone who wrote a village jurisdiction, which is not a city or a township, we thought that the best interpretation of the statute was that if the individual put the city or township that was their mailing jurisdiction, and this was in fact accurate, that would satisfy the statutory requirements.
Thank you, sir. Ms. Cummings?
I don't have anything else.
One of the things that we have dealt with repeatedly is circulator certificates, because obviously it affects the validity of all of the signatures on the on the petition sheet. And we have recognized that the people who signed the petition sheet did so indicating their support for whatever was on the sheet. So to the extent that where the Bureau recommends that the circulator certificate was appropriately filled out, given the complexities of Michigan addresses, I would accept the recommendation of the staff so that we're not disenfranchising all of those people who signed those petition sheets.
Okay, thank you. Thank you. Thank you for your time, Mr. Ziegler.
Thank you, Chair Hauskamp.
Someone here from Mr. Tanis's.
Oh, aye.
Okay.
Just flagging before there, I think there was at least one other petition where this issue came up. I don't know if you wanted to have all the argument around this issue now. I don't know if anyone else wants to weigh in on the Wickman City Township issue.
Would we have anyone that would please come forward?
Just to clarify, the reason I'm just suggesting that is just for the sake of efficiency, because there's at least one other candidate where this same issue about the circulator address is coming up, and it may just be more efficient and fair to everybody that all the council that want to present on this issue, present you so you have that information before you make essentially the same determination for multiple candidates.
Please come forward. You need to turn on the mic and state your name and your spelling.
Good morning, Mr. Chairman and members of the board. I'm Rowan Conybeare, ROWAN CONYBEARE of Dykema, appearing on behalf of Miss Andrea Banfield, a candidate for the 44th Circuit Court. This morning, we ask that you adopt the Bureau's recommendation and determine that Miss Banfield's nominating petitions are sufficient. Ms. Banfield submitted nearly 1,000 signatures, over a third of which were challenged by Jeremy Scott Gibbs due to an erroneously expansive reading of the Court of Appeals opinion in Wickman versus Norway Township Clerk. As an initial matter, we do not believe that Wickman applies to nominating petitions filed under Section 544C of the Michigan election law. At issue in Wickman were referendum petitions, which are governed in part by Sections 482 and 482A of the Michigan election law. As the Wickman court found, Section 482 requires that if a referendum petition does not meet all of the requirements of Section 482, then, quote, any signature obtained on that petition is invalid and must not be counted. In contrast, in protecting Michigan taxpayers versus Board of State canvassers, the Court of Appeals held that Section 544C, which we're working with because it governs nominating petitions, they held, quote, makes no allowances for striking electors' signatures in the event that a circulator records an incorrect address, and nothing in the relevant statutes conveys any intent to disenfranchise electors who were unaware of a circulator's error or infraction. This makes clear that even if Ms. Banfield's circulators provided an incorrect address on her nominating petitions, the result is not to invalidate all of the signatures on her petition sheets. But even if Wickman does apply to the nominating petitions, Mr. Gibbs' challenge should still be rejected, as the Bureau recommends in its staff report. The Bureau correctly concluded that Wickman was limited to the facts before it. A circulator certificate that lists an unincorporated village in the space for the city or township is invalid. But nothing in Wickman or Section 544C prohibits a circulator from using a mailing address when that mailing address is also a city or township. This correct interpretation of Wickman rehabilitates nearly all of the challenged signatures, placing Ms. Banfield well above the 600 signature threshold needed to make the ballot. We respectfully ask that the board comply with its clear legal duty to certify Ms. Banfield to appear on the August ballot. Thank you for your time this morning and your hard work in reviewing all of these petitions. I'm happy to answer any questions that you may have.
Thank you very much. Questions? Shorties? Nope. Thank you for your time.
Okay, thank you very much.
There's discussion we need to have here.
So in each of these, the staff has made the same recommendation. And as I indicated, when Mr. Ziegler was speaking, I think the staff's recommendation is one that we should accept. It does give effect to the intent of the people who sign the petitions. And I think that the challenge the challenge to Mr. Tanis's petitions and to Ms. Banfield's is not a reasonable or it's not a reasonable interpretation of Wickman, but also not a reasonable interpretation or correct interpretation, I should say, of the statutory requirements.
Are you putting that into a motion?
Would.
I thought maybe you were going in that direction.
With regard to agenda item number 7, nominating petitions submitted by Philip Tanis. I move that the board accept the staff recommendation and find the nominating petition filed by Philip Tanis sufficient.
Second.
I moved and seconded. All in favor?
Aye.
Aye. Okay.
And then we have to do
Could we do the
We-
same
we are-
one for
Banfield.
Banfield? Item number
If
13.
if you, we probably could, but can we hold off on,
Sure.
on getting there?
Yeah, I mean, I don't know.
Or do you want to do that one right now? I'm fine if we're, I want to be careful if we're moving items around because we have one that we just moved over, right?
Okay,
Yeah.
yeah, so to clarify, what we're talking about is because we just talked about Banfield, going to that one next, or going to the general motion for the other candidate?
Correct. If we
Okay.
could do the,
Okay. Yes.
Director, if we can do that, then what we'll do is we'll get the agenda back on the right numbers here.
Okay. So, so this would have been agenda item 13, but there was a common issue. So I had recommended that it would just be easier for the board to hear that all that argument at the same time and make the same decision for the same decision on the same issue for multiple candidates. Otherwise, regarding Banfield, so this is 44th Circuit Judge, non-incumbent position, required 600 valid signatures. They submitted 995. After our face review, we determined that 954 were valid. There were some that had, the most common issue are date issues, like the signatures being dated after the circulator signature or missing dates. There was this challenge that was already discussed about 401 of the signatures that did involve the same issue that we just discussed. The reasons described, we determined that that was not a basis for rejecting the signatures. And so that we did find other things in the challenge that we did agree with. There were 47 signatures that were deemed invalid after reviewing the challenge because of other information missing. And I think some of those did include situations in which the circulator did actually put like a village or an unincorporated area as their residence, which, as we understood Wickman, would be a basis for disqualification because it was not any city or township in the box. Democracy in action going right by our window. We determined that based on even reviewing, taking those out, she was still left with 907, which is well over the 600 required. So we would recommend certification.
They're not on the agenda. Would you just, I missed that last piece.
Oh, sorry. So anyway, after we had processed all the petitions, I think we're all a little distracted. We found that there were 907 valid petitions even after the challenge, so which would put the candidate well over the 600 required. So we'd recommend certification to the ballot.
Okay. Do you have anybody here for? Unless there's discussion.
Again, I agree with the legal framework, and I just think the bar should be so high to remove valid signatures via a circulator that this is a no-brainer.
Okay, so we have a motion.
I move that the board accept the staff recommendation and find the nominating petitions filed by Andrea Banfield sufficient.
Second.
All in favor?
Aye.
Aye.
All right. Director Brader, we would like to come back to let's come back to the report on the review of nominating petitions other than for governor and U.S. Senate filed with the Secretary of State for the August 4th, 2026 primary election.
Yes, thank you, Chair Housekamp, and apologies to everyone. We did go a little bit out of order there, but we're going to get to everything. So we have done now agenda item 7 and 13, and we're now jumping back to item 6. And this is the report for all the candidates other than those for governor and U.S. Senate who filed nominating petitions. And these are ones where there was no challenge filed, and we determined that there were sufficient number of valid signatures. So these are ones that we are recommending in a group that the board certify to the ballot. Again, this does not count governor and U.S. Senate. We'll be handling those ones a week from today. Just to note on this, I just want to convey appreciation to BOE staff. We had in total 128 candidates, including both these ones and the ones we'll talk about next week. that submitted nominating petitions. That totaled almost 500,000 signatures on over 70,000 petition sheets. So this was a very large effort, a lot of late nights, early mornings, weekends, and our staff really worked extremely hard to get through this work and to try to do the best job we possibly could to review everything properly, get the information out to people who are requesting it, and ultimately make the right recommendation. I also appreciate the board's work over the last current election cycle. You know, our goal is that, you know, we want to get all the information out to all the candidates in advance so that we're all working from the same set of information and facts as best we possibly can. So the board, appreciate the board's thoughtful review and work with us as we put together updates to the petition manuals, to the filing manuals, so we could try to get as much information out as we can. There are always, of course, some new issues that come up, like the one we just talked about. And so we'll you know, continue to incorporate that in future cycles. But I think the staff really did a great job and worked extremely hard to get these before you. So with that, these are the general non-challenged sufficient petitions for candidates other than governor and U.S. Senate that we're recommending you certify to the ballot.
Thank you, Director Brader. We have any conversation, not really needed anything here, do we?
I think so.
I'd really kind of like somebody to put up a motion and then we can,
Looks like does the secretary have to read something here?
I've
got it right here.
Is there something I'm supposed to read to them? Sorry,
oh, I'm sorry. Okay.
I don't literally have to read that, but just to make sure we're not missing anything, I will just add some details. So the list you have before you contains the names of candidates who have filed a nominating petition found to be sufficient under a review carried out by the staff for all offices other than governor and U.S. Senate. Those candidates will be those candidates for governor and U.S. Senate will be certified at the board's next meeting. The candidates in the certification document before you are seeking nomination to the offices of state senator, state representative, judge of the Court of Appeals, judge of the circuit court, judge of the district court, and judge of the probate district court, and also U.S. representative in Congress. Those candidates who have matters regarding the sufficiency of their petition pending before the board today do not appear on the list. We're dealing with those separately. And then prior to addressing the remaining petition sufficiency issues, staff recommends that the board adopt a motion finding the petitions filed by the candidates whose names appear on the attached list sufficient.
Thank you, Director. Now,
I move that we accept staff recommendation and find the petitions filed with the Secretary of State by the candidates appearing on the list sufficient, with the understanding that the list does not contain the names of the candidates who filed for governor and U.S. Senate and does not contain the names of the 9 specified candidates who have petition sufficiency issues pending before the board. I further move that the candidates who filed a sufficient petition with the Secretary of State for the offices of U.S. Representative, State Senator, State Representative, Judge of the Court of Appeals, Judge of the Circuit Court, Judge of the District Court, and Judge of Probate District Court be certified to the Secretary of State for the August 4th, 2026 primary ballot. This certification is to include any additional candidates who we find to have filed sufficient petitions under today's hearing.
Second.
second. It's been moved and seconded. All in favor?
Aye.
Aye. Moving on, item number 8 on your agendas is consideration of the sufficiency of the nominating petitions submitted by Michael Bouchard for the office of U.S. Representative, 10th District. I have a challenger here. I have a number of you. Yeah.
Should I go ahead with the
Excitement
staff
here, we
report?
lost the list. I'm sorry.
Should I go ahead while you're with the staff report?
Oh, yes, forgive me.
So, so I know we do have some speakers here, but, so this is a candidate, Michael Bouchard, U.S. Rep in Congress, 10th District, Republican, primary, needed to submit 1,000 valid signatures, submitted 1,837 total. In face review, we determined that 1,830 were facially valid. There was a challenge to all 1,837 of the signatures on two bases. One was that the petition sheets did not include a disclaimer described in the Michigan Campaign Finance Act for basically who paid for this, which is commonly referred to as the pay for by disclaimer. Then the separately challenged that there were signatures that were dated more than 180 days before the petition was filed with the Secretary of State. So that in general would cover all the signatures in the petition. So of course, if those were all accepted, that would take the candidate under the threshold. So we process the petition. So in evaluating these challenges, first talking about the Campaign Finance Act one. So there's a couple of reasons why staff determined that that would not disqualify signatures here. First of all, this is a candidate for U.S. representative in Congress, so it's for federal office. So this candidate is running, their campaign spending is regulated by federal campaign finance law, the Federal Election Campaign Act, and the Bipartisan Campaign Reform Act. And the Campaign Finance Act, the State Campaign Finance Act specifically excludes federal candidates from the definition of elective office that is regulated by state campaign finance law. So that's one thing. Even if this were a situation where the Campaign Finance Act applied, there's a longstanding policy that the paid for by statement at least may not be a violation of the Campaign Finance Act. There's a 1978 interpretive statement from the Department of State that indicated that the paid for by statement is not required on nominating petitions because it's already clear because the candidate's name is on that petition who's paying for it. And it would only apply if there was some sort of detachable sheet where you wouldn't be able to tell who paid for the statement. So ultimately not relevant because this is not a candidate that's regulated by the Campaign Finance Act, but even if they were, we don't think it would necessarily apply in any way. And then the 180-day limit does not apply to partisan nominating petitions. That applies to qualifying petitions, but that's a separate section of law, section 590B. There's no such 180-day date limit when you're talking about nominating petitions. Those can be collected essentially the day after the last election for that office, which would have been in November 2024. So we didn't accept that challenge either. And then based on those two determinations, we recommend that the petition be determined sufficient.
Thank you, Director Brader. Mr. Dostra, I have you. He's got it all? That's a first. We'll have that highlighted in a minute. Is there anyone else here representing Michael Bouchard? Okay. I'm sorry.
I think council is pointing out that we previously on the circulator petition issue considered the same arguments for multiple candidates. And so I think council's just seeing if you want to hear.
Technology.
Yeah, if you want to hear the argument.
And if you don't have anything else to add, we're going to keep moving through. Thank you. Director Brader, if it comes up again and they'd like to add something, we'll bring it in. I think we're all in understanding and in agreement, right?
Yeah.
Do we have a motion?
Yes. I move that the board accept the staff recommendation and find the nominating petition filed by Michael Bouchard sufficient.
Second.
2 seconds. That makes it really good. All in favor?
Aye.
Aye. Moving on, consideration of the sufficiency of the nominating petitions submitted by Stefan Dimitriopoulos for the office of U.S. Representative, 10th District. Director Brader, would you read the staff report?
Yes, hopefully I can be heard. This is another candidate for 10th District This is on the Democratic side, but also 10th District in Congress. So in this, candidate also was required to submit 1,000. They submitted 1,336. Following face review, we determined that 1,301 of those were facially valid. There were some that were determined to be invalid based on date issues or heading issues, but the candidate was left with 1,301. These were challenged on the same basis by the same challenger as the Bouchard petition. So this would involve the Campaign Finance Act statement and the 180-day challenge. We, for the same reasons, rejected those challenges and would recommend determining the petition to be sufficient.
Right. We have Mr. Barrett Young, oh, I'm sorry, that is on the wrong agenda item, forgive me. We have no one here for petition. That's the case, then I would entertain a motion.
I'm sorry, just one correction. He's actually a Republican primary candidate. I said Democratic, but Republican.
Yeah, I can do it. Sure. I move that the board accept the staff recommendation and find the nominating petition filed by Stefan Dimitropoulos sufficient.
Second,
Second.
moved and seconded, all in favor?
Aye.
Quick update here. We're going to move to item number 10, which is Robert Lugerai. And then before we do that, though, we're going to move to item 10. And when we're finished with 10, we're going to break for lunch. Does that work with your schedule?
Fine with me, whatever the board's preference is, yeah. I think as of now, knock on wood, we're on track, so whatever the board wants to do with the remaining time should work.
Right. So consideration of the sufficiency of the nominating petitions submitted by Robert Lugerai for the office of U.S. Representative, 10th District.
So same office as previous candidates. This is 10th District, U.S. Rep in Congress, Republican candidate. This candidate submitted 1,681 signatures. Following staff review, we did determine that 108 of them were invalid for face reasons, and most of them being that the address given was outside the district of the district. So it may have been in the city or township that the signer indicated, but they didn't live in the 10th District, so they could not sign the petition. We also did identify during face review some signatures that were of dubious authenticity. So when we're doing face review, we're not looking up each individual signature in the qualified voter file at that stage, but if we see signatures that look dubious, we will note that. And then, depending on the number of signatures and challenges, we may then look those up if it is potentially affecting whether the candidate has a sufficient number of valid signatures on the ballot. So we did identify a total of 236 that were of dubious authenticity. So, but even if we took those out and looked them all up and they were all invalid, the candidate would still have a sufficient number of valid signatures at that point. So that left at that stage the candidate having enough. We did receive a challenge. The challenge also involved candidates that signatures that were noted as being potentially forgeries or of dubious authenticity. And then also the challenge raised the same issues we just talked about with the Campaign Finance Act and the 180 days. So rejected those other categories for the reasons described. But we did review the challenge and determined that at least initially determined that the the cushion that the candidate had over the 1,000 signature threshold was sufficient that even if we threw out all those signatures, they would not take them under the 1,000 threshold. So that was the basis for determining the petition to be sufficient. We then subsequently got an additional comment that was raising questions about whether that calculation was correct and whether we should have in fact continued to process signatures, process challenges, because according to that additional information we got, there was a sort of challenge that, hey, if you actually looked at these challenges, you might actually disqualify enough signatures to take the candidate under 100. So one of those is from Mr. Doster, one is from Mr. Kirk, and they alleged that the signatures were actually challenged on multiple bases and that we should have fully processed the challenge. And so when we looked at that, we agreed that actually we should have been reviewing more of those challenges that were made on multiple grounds, because if we had evaluated them on one of the grounds that we hadn't already determined to be not a solid basis for a challenge, we could actually have processed them. So one challenge was received from Mr. Doster. That was received with more than 48 hours before the meeting, so we did process that additional challenge. And then we did not process the one from Mr. Kirk because that was received within 48 hours of the hearing, so it missed the board's deadline for reports. So after we processed the additional challenges, there were 474 of them. We agreed with 181 of the challenges, and we rejected 174 of the challenges, and 119 of them overlap with our initial determination. So after we removed those additional signatures, there were 278 signature challenges remaining in the submission, and Lugerai was 361 over the number required to be sufficient. So even if we had rejected all 278 of those signatures, it still would have left him about 80, 90 over the threshold. So we didn't process the rest of those. So apologies for the multiple stages and disjointed explanation there, but ultimately we did look at that challenge again, and we still recommend certifying because even with those signatures taken out, the candidate is still over the 1,000. Adam, is there anything you want to add to what I just said? Okay, that's all then.
Thank you, Director. We have a number of folks that are planning to speak here. Mr. Doster, are you still planning to speak to this? I would invite you to speak to it. Yes. And if you would both state your name and.
Of course. Eric, ERICDOSTER. Of the three Erics up here, I'm the only one that spells my first name correctly. On behalf of Duty, Honor, and Discipline PAC.
Eric Spekeen, ERICH, which is correct. Last name is Spekeen, SPECKIN.
Mr. Spekeen, we're really two speakers here. Mr. Spekeen is no stranger to this board, as both Chris Thomas and I have used Mr. Spekeen to conduct forensic signature analyses and petition managers before this board for many years. So again, we're actually two speakers today, but it makes sense that we kind of come up here together. I'm going to make a few comments. Actually, I'm just going to ask a question based on what Director Brader said. How many over is Mr. Lugerai based on your last analysis?
So we determined that he was 361 over before we processed the 278 signature challenges that were remaining. So 361 over if we had accepted all those challenges, agreed with all those challenges, and rejected those signatures, that would leave him at the risk of doing math on the fly, I think 83 over. Is that right? Yeah.
So you're determined, I'm sorry, I'm just asking because we haven't seen a revised staff report.
Right.
That's why I have to ask these questions, so I apologize. So you got him at 1,083 right now?
1,361 before reviewing the remaining challenges that we determined were not necessary to review. But if we had accepted, agreed with all those challenges and taken those signatures out, that would leave him with 1,083.
Does that include any of the fraud signatures? Does that
would
take those out?
include- That would be assuming we reviewed the alleged forged signatures, yes.
Okay. I think that the only comments that I'm going to make is there actually, again, we haven't seen a revised staff report. But the only comments is our numbers on the fraudulent, number of fraudulent signatures. We don't have this Angela Vulai at 236 is what I believe the staff had. We actually went through and there are 32 petition sheets totaling 243. So we've got 7 more there than what staff had initially determined. Again, that number itself is not determinative, but anyway, well, thank you for those clarifications. I would assume we would see a new staff report and be able to comment it at some point. But we'll get to that in a second. So thank you for going through and processing the individual Kirk challenges. Again, we're not here to add additional challenges. We're only here to comment on the challenges and whatever staff report is before the board right now. The one part of the staff report that we were able to see that is complete appears near the end of the Lose Your Eye staff report, where fraudulent signatures are referenced as, quote, independently identified by staff during face review of the petitions as appearing to be of dubious authenticity, end of quote. And thereafter, and I hope I'm reading this part of the staff report correctly, it appears that the Lose Your Eye petitions are being considered as part of an investigation of those signatures by the Michigan Department of State's Office of Investigative Services. So to assist in this effort, I would like to turn to Eric Spakeen now to provide this board with his conclusions and findings thus far regarding the Lose Your Eye petitions of, quote, dubious authenticity. I can't say that. Authenticity. Thank you. End of quote.
So it's probably, I have some graphics to demonstrate to the board because it might be easier to see. So we're all looking at the same thing and they're blown up. So they're pretty big. Everyone should be able to see them. I'm going to step away from the mic, but I have a pretty loud voice. So I think we'll be
As
okay.
long as you
if I
don't put any
speak up.
tacks in that wood, you're fine.
No tax with
You're
me.
good.
So I think we're good. Okay. So there are 2 different types of issues that I see in primarily 2 circulators, but at least of a large volume. And I think the board has seen my report. So there was one that was the Angela person. And that's a case where the writing, and I'll demonstrate it in just a second, matches that of the circulator, not just for the address and city and state information, but in the signature. And I understand there are cases that allow for the address and city and state to be provided assistance, but of course not the signature. The second type is an instance where there are multiple entries written by the same person, and this is a different circulator, that does not match the writing of the circulator. In other words, if it's written by multiple people, the voters didn't write it, the circulator didn't write it, and we have no idea who did write it then. Not to mention the signatures bear, in those instances, remarkable similarities in formation to one another in the way it's done. All right, so here's the first one. And this is writing on the Angela, and I'll just say her and everyone else trying to pronounce the last name just like Angela for now. So this is writing from her circulator attestation or block on various petitions. And here is writing from the voter's information of the name and address. Now, I think the staff already saw this. I think everyone has probably seen it. I won't spend a lot of time because I know I don't have a lot. But you can see that the characters, the A, C, especially the R, I've even picked out the words Rochester, the 4s and the 8s, the S with the letter combination, and so on, matches that of her writing. So that's going to show that she filled out the name and address portion on many of these petitions. What becomes significant then is to look at how the signatures look when you have someone providing assistance, which in the right circumstances, of course, can happen. Or when done correctly. So I have a black line across about a third of the way down. What's above the black line are various signatures of Angela from her circulator attestation. And you can see, I tried to group these with a little bit of a style. So you have what looks like a cursive A to start on the left-hand side. You have these straight squiggles here, and you have a capital A here. The last names are all very similar in how they're formed. These signatures here are a sampling of alleged voter signatures that bear remarkable resemblance to the way her signature is formed. These are also signatures where where we have her filling out the voter information of name, address, city, state, zip. And also the signatures are spot on to her signature. Now, of course, there are different names. So you have like this one, for instance, in the center starts with an S. Of course, it's not going to match her A. But when you have the indescript nature of these last names, for instance, down towards the bottom of the middle row, just to pick an example, but you can see many of them. They're done by the same person and it matches hers. Here's a group. I'm looking at the one row in from the right hand side. And we have numbers 3, 4, 5, 6, and 7, and 8. And this is a family with the same last name. And you can see the remarkable similarities of all of these signatures. And yet you can look at, especially towards the bottom, matching almost exactly with the way she signs her name. Now, the second type well, let me just show, and I'm gonna make this one very quick because I don't want to waste your time.
Can I actually interrupt real quick? Can I ask you to move a little closer to the microphone, please? The live stream's struggling to hear.
Yeah.
Thank you.
Okay, sorry. So this is a group of signatures. I'll just use this one example here. Again, you've got a family, all signed by the same person.
And for the afternoon. Mr. Kirk. Mr. Kirk, before you start, here's how we're gonna go. We're gonna hear your challenge. Is Mr. Barrett Young here? Is Mr. Young here? Okay, we're gonna hear your challenge. You're representing Mr. Ludroy? Okay, we're gonna hear your challenge. We're gonna then hear you. And then we're not gonna vote. We're going to update the staff numbers. The elections folks need some time to do that based on what we've done here, based on their recount. And then we are going to vote when that's finished, which will be probably later in the afternoon. So we will vote this afternoon, but we'll hear the rest of your stuff now. Is that fair? Is that clear? Okay. Now, once the numbers come back based on what you've all said, we'll probably have our vote. Would you state your name and spell it for the clerk? And you've got 5 minutes. You want to distribute those to us? You may if you'd like. That's the one you sent in with less than 48 hours. So we're not really gonna consider this. Okay.
Thanks.
It is outdated.
Okay. All right.
Sorry, I'm new to all this. Members of the board, thank you. I appreciate you guys giving me the opportunity to speak. My name is Justin Kirk, JUSTINKIRK, and I'm here on behalf of myself regarding our challenge to the nominating petition of Robert Lurjai. And we believe that a comprehensive review shows that the candidate has submitted less than the statutorily required 1,000 signatures. I'm happy to hear that the staff has conducted a revised analysis. Please understand my presentation is now stale due to these revised numbers, but I want to build on what Mr. Doster stated before me. We did FOIA the staff's workbook in this case to understand their underlying numbers and, for instance, the discrepancies between what we found of 509 not registered voters and the staff's finding of, in the original report, 83. So we have had that FOIA request was filled today. So we have this morning, actually, we had not had time to examine that comprehensively. But Director Brader, I'm sorry for interrupting, but I was in the back there wherever the cheering was going on, so it's difficult to hear. Can you please walk me through the revised analysis now, 1681 total signatures? Can you tell me how you got to the 1083 new number that the staff is promulgating?
Yeah, so we had, what was our number after, the original staff report? After the challenge, what was that number?
1571, I believe, off the top of my head.
No, but that's after the second.
1573 was after face review.
All right. Okay, so it was 1573. We didn't, after in the initial staff report, we didn't remove any from the total after we reviewed the challenge. Okay, so our original staff report, after we did phase review, we were down to 1,573 valid signatures. We then reviewed the challenges we received from yourself as well as, well, just, I think it was just you. And then we, for the reasons already described, we determined that although we had also identified some of these signatures that looked dubious, even if we took all of those out of the 1573 and also the other ones that were raised by the challenge, other than the things we talked about the Campaign Finance Act and the 180, that would still leave him with a cushion of there weren't enough in question to take him under. So we then got, after we published the staff report, we got a comment received from Mr. Doster, who did not make a challenge, but did respond to the staff report. And he flagged that, he had looked at the staff report and determined that actually there were some additional challenges we should have considered because they were challenged for multiple reasons, and we had only mentioned them as challenged for one reason that we had rejected. So we took another look at that between when we received that comment 48 hours ago and this morning, and we determined that even looking at all of the additional signatures that we would have reviewed as possible challenges, I think all being signatures that were alleged to be forgeries, that would be, I think it was 278. Is that right? So even if we took those 278 out of the 1361 we had, that would leave us with 1,083. So we didn't process or review those individual signatures. So that's where we are as of now. Staff is currently reviewing that to make sure that those numbers all reflect exactly what we did, but that's where we are.
Okay. I'm thinking about the workbook that we received. It also indicated that there are 274 unprocessed challenge signatures. Is there an updated figure on that?
Those would be the same one, but it was 274 in that report.
274. So that includes the Vulai
Yeah.
forgeries. Does that include the Gianna Peconic signatures?
I believe so. But
Okay.
I'm just verifying. Is that also, that's not just the lie, right? That's the other person too? Yeah, that would include all the dubious ones that were flagged.
Okay. We still, have not seen this revised staff report. We would like the time to respond to it. Because like I said, we found 509 not registered or out of district signatures, and staff found, I believe, less than a quarter of that. So that's a fairly large discrepancy that we would like to have the chance to investigate. I think it's clear that there's a lot of ambiguity here. After Mr. Spakeen testified here or spoke here, we looked at the Joseph Burjai signatures as well. There are 67 of those. And there's also another individual, a Rodney Pearson, as a circulator who has 131 signatures that we believe are of dubious authenticity. Another factor that we believe is relevant on the whole is that of the 241 nominating petitions, 104 of them, those signatures were collected on the 18th, 19th, and 20th of April. So that's 40% of all signatures were collected just before the filing date. Sure. So of the 241 total pages that were submitted, 104 of them included collection dates of the 18th, 19th, and 20th of April. So that's almost 40% collected just before the deadline. So I think if we're thinking in terms of fraud here, I think that leans in, at least that's a factor in favor of it. Looking at the Vulage signatures, the Burjai signatures, the Gianni signatures, and the Rodney Pearson signatures, that total comes out to 634. And although staff has said that they've included all of the Vulai signatures in their count to get down to 1083, we believe that there could be other discrepancies, including the possibly hundreds, the difference in hundreds between what we found to be not registered against what was an up-to-date QVF file and what staff had found, as well as these other individuals who have these potential, there's evidence of fraud there that equates to, I mean, if you just take Rodney Pearson, 131 signatures, that gets you below the 83. Joseph Burjai is also 67, Janet Pekonik, 193. So I think there's enough of these potentially fraudulent signatures. I mean, potentially 643 of them, but definitely more than the 83 that have not been considered by staff that would get us below the 1,000 minimum. And so, any fraudulent act violates MCL 168.544C8. I know you guys know this, but signing petition with a name other than one's own, and MCL 168.544, signing petition with multiple names. It's a felony. The board has expressed authority under MCL 168.552 to hold hearings, subpoena witnesses, and its authority under MCL 168.544. They can disqualify, obviously, fraudulent signatures without checking them against registration records. So that's all. We're asking for the same relief as Mr. Doster asked for, which is just an adjournment of this decision. I understand that the board may take a vote on this, but we would just like time to investigate this updated staff report, which we still have not seen online in paper form. We have not been provided a copy of it. Like I said, we made 752 individual signature-based challenges, and we want to make sure that each of those has been addressed correctly. As we all can see, this gets pretty bogged down in complexity and ambiguity. Some of these challenges, especially when there's overlap between a potential fraud, forgery, and not in the district, or different reasons for rejection. And we want to make sure that all the signatures have been processed. Election integrity, it depends on precision, transparency, and consistency. And if there is potentially unprocessed challenges here, I think that further underscores why the board can't simply accept these totals at face value. So just in summation, we're not asking the board to prejudge anything here. We are simply requesting that the board take additional time to conduct a comprehensive review and specifically complete a review of each signature against the qualified voter file, including the QVF signature file and voter registration information. This relief we do not believe to be extraordinary here. Based on the circumstances, what you've heard from Mr. Doster and Mr. Spakeen, we believe that that is the reasonable and responsible course. Thank you.
Questions? Ms. Cummings?
Did you see any?
Microphone.
Did you see any correlation between what you said were a large number of petitions filed at the last last couple of days. And petition sheets where you identified problematic signatures.
Well, I think if we look at the whole, the amount of signatures, 634 have been collected by circulators where there's been some type of evidence of fraud. I think that that's a correlation there. I think the timeline just lends itself to, if you're looking for fraud, if you're looking for a reason for conducting that fraud, if you're short on signatures and you're coming up to the deadline, I think that just lends itself further in favor of that decision.
So you counted the number of petition sheets that were collected in the last couple of,
Correct, 104 of 241.
but, and did you count the number of petition signatures that were collected by particular signers within that period of time?
I don't have that number for you offhand, I'm sorry.
Okay, and I just wonder because,
Mhm.
when I've looked in the past, it seemed to me that a large number of signatures collected in a very short time was, by one
Mhm.
circulator,
I would-
was indicative of,
You know,
possibly indicative of, possible lack of authenticity or
Yeah,
whatever
yeah.
we want to call it.
And I know I'm not an objective observer, but I would also agree with that if it's collected towards the end, there's a mass amount of number, especially 104 pages out of 241, approximately 40%. I think I would agree with your point, so.
You have the petitions pulled up. It's multiple circulators with those dates on it. And I would just say as someone
Correct.
who's worked for candidates before, it's not abnormal for everyone to freak out at the end and and start putting a lot of effort behind it. So I don't know if that's necessarily a true indicator of fraud, but.
There's sometimes a lot of effort in very widely dispersed places by one person.
Sure.
Won't be
Yeah.
kind.
I was out there in February getting mine, so I didn't have to rush at the end, so.
I have nothing further.
Director Brader, do you want to weigh in on anything that's been said here?
I think, so one thing I'll just note, I don't think I was clear about this before, is that within some of the petitions that were collected by some of the circulators that did have dubious ones, or whatever you want to call it, when we looked some up, we did find some good signatures. So it's not, even though obviously we're going to refer some of these circulator signatures for investigation because of what appears to be forged signatures, some of those people may have also collected valid signatures. So it's not necessarily the case that, and we think that they did. So it's not necessarily the case that every single signature that those circulators submitted needs to be thrown out. That's one thing. The other thing is that I agree that the fact that these numbers are overlapping can cause some confusion, and certainly recognize that from the perspective of the candidates and the challengers. I think what will be most useful is when we can give a little bit better breakdown explaining which of these signatures that have been challenged we already either rejected, and for the reasons we can explain or already have explained, or that we have already accounted for in our math as overlapping with our own determinations. So I think it will be clearer when we can provide that information, which hopefully we can do soon.
I would like to make a comment on your first point. I agree that it doesn't, just because there's fraudulent signatures, it doesn't mean everyone's fraudulent. But I would reflect back to the original staff report where they examined 20 signatures on petitions collected by Angela Vulai, and only one of those was found to be valid. So I think, you can't extrapolate that number completely, but I think you can use round numbers. And like I said, when there's only an 83 signature cushion, I think we've demonstrated that when there's potentially an additional 260 signatures, if you just look at Joseph Burjai and Jana Pekanek, or even add Rodney Pearson in there with his 131, I think that there's definitely more than 83 signatures at issue.
Right. Thank you for your time.
Thank you guys very much. I appreciate it.
Gentlemen, if you would turn your microphones on. And again, names and spell for the clerk.
Yes, good afternoon. Steve Etherly, last name spelled Eatherly, on behalf of Robert Lugerai.
Barrett Young, Barrett and Young on behalf of the same. For the reasons articulated in our response, the staff report, our comments to this board, and Director Brader's comments today, we request that you all adopt the staff report's recommendation and the subsequent one, presumably, and conclude that there are a sufficient number of signatures. Mr. Doster and Mr. Kirk are attempting to come in after the fact, and you should not entertain what they are trying to sell you. In particular, Mr. Doster came today with sort of vague accusations about hundreds of allegedly forged signatures, and yet Mr. Brader and his team gave Mr. Doster the benefit of the doubt and accounted for all of the supposedly forged signatures. And then Mr. Kirk today is coming in after the fact, trying to bring up new challenges, even though he had an opportunity when he got all the petition sheets and the staff report. He had his opportunity to identify all of the alleged problems, and he had a Exhibit A in a table, and now he's trying to improperly add to that. So we encourage you all to reject that. And I'm going to turn over to my colleague now. He has some points he'd like to make as well.
Yes, thank you. I appreciate Mr. Brader's correction on the number of 243. That's the total number of Ms. Village's signatures on there. It's not the number that were deemed, fraudulent or forged. Our position is that the board does not need to address the Village sheets, given that Lugerai still has sufficient total number of valid signatures. Many of the electors on the Village sheets, whom Challenger seeks to disenfranchise, are members of the Albanian American community living in the 10th Congressional District. The board should not disenfranchise all the electors' valid signatures based on select Angela sheets showing dubious authenticity. For example, in the first staff report, the staff admits that some signatures on questionable Angela sheets may be valid, and that's been highlighted today. The Court of Appeals in protecting taxpayers has ruled that the penalty provisions under 55-4C are narrowly drawn, and even in the event of knowing and intentional violations of the law, the legislator omitted from the list of punishments an automatic disqualification of signatures. Instead, only obviously fraudulent signatures are struck. As we've highlighted today, that there are signatures on the Angela sheets that are valid, and also shown is the Exhibit 1 to our comments, where we collected 12 electors who signed Angela sheets, and that was across a cross-section of her sheets that said this was their signature on these sheets. So you can't throw out all of the valid signatures that are on the Angela sheets. And that also comes from 544C subparagraph 6. The invalidity of one or more signatures on a petition does not affect the validity of the remainder of the signatures on the petition. We've also highlighted, or going to Mr. Spakeen's report, that the time for identifying, that's today. There has been no identifications on the Village sheets or on the Johnny Parakai sheets on which sheets are problematic and which signatures are problematic. They are just saying that the board should engage in a fishing expedition because hundreds should be deemed invalid. The time for them to put that was today and actually earlier in a challenge, whereas Mr. Doster filed comments and also provided the Mr. Spakeen's report. So we'll turn it over, you have anything else to add?
Well, I mean, we're happy to.
Happy to field any
questions.
questions, yep.
Questions? Supported. Ms. Cummings? No?
I would just wonder if Mr. No,
Lose your eye.
Lose your eye, okay. Reviewed the petitions before they were submitted, because some of them are so obviously forged. I mean, we had this trouble, obviously, as you well know, in 2022. And considered what the responsibility was of the candidate as well as of the petition circulator. So I just think it bears some examination, or at least thought about the responsibility of the candidate.
I believe there is responsibility. But also as highlighted, even on some of the problematic sheets, there are valid signatures on those. So if you just throw out the sheet, then you're going to be disenfranchised that elector that, is supporting our candidate. And I also understand, there's been mentions earlier today about the governor's race in 2022. We're talking about one unpaid volunteer circulator. I believe she's young. We're not talking about widespread fraud like what happened in 2022. So the board needs to follow the statute and count the valid signatures that are there.
I think to her point, there's a couple of sheets that are really bad with zero valid signatures on it. So I just think that, if doing due diligence and looking through these, like there's a couple of sheets that you could just crumpled up and thrown in the garbage, and those are highlighted in the staff report. I think that that's probably a fair statement.
That's fair.
Director Brader, would you like to address anything that's been said here?
The only, I will say, just on the point of if a sheet has one good signature and multiple bad ones, I don't want to belabor this. I agree that it's not at the level of what we saw in 22. You can also cross out signatures, right? So you could cross out apparently 4 signatures and still submit the good ones. But in terms of the numbers here, I think it would benefit the board if the staff are still trying to make sure we explain numbers. I understand, and I apologize for not necessarily being able to add these all up in a way that completely makes sense to everybody. Part of the issue is that we have signatures that were challenged. We also have signatures that were raised that were not challenged, but that are sort of being raised within 2 days, which isn't really a challenge that we consider under the challenge process, but we want to account for it in the numbers so that you know what you're looking at. So staff are trying to put those numbers together and break it down in a clearer way for all of you. So my recommendation would be to hold on this while we deal with the other petitions that are on the agenda. And then by the time we're done with that, we'll either be able to give you a little bit more of a clear picture, or just tell you that we're not going to be able to do that today. And you can determine based on what you have before you, how you want to proceed. I will say that while I understand that there's some confusion, I am confident that with these additional signatures that are being mentioned as potentially fraudulent or are already challenged, we do already account for those in our numbers. I acknowledge that we can explain that more clearly, but we do already account for that in our knowledge. So our view is still that there's a sufficient number of valid signatures, even assuming that these additional challenge ones are all invalid. That's what that 1,083 number represents.
That number could actually go up.
Yeah, it could.
Depending on what you find.
If you feel you feel while we're doing the rest of these petitions, if you get a sense that you are not able to, your team can't put those numbers here today, will you flag it so that we can figure out what our other options are?
Yeah.
Thank you.
And I would note that the 48-hour rule is one that we adopted in 2024 because we had a candidate who brought more signatures each day for several days in a row, which was very challenging to us, to put it mildly, right? So we need to, if people are going to challenge, they need to do it in a timely way. And coming later and saying, you know, there's a lot here, look at all of it. It's not what we should be doing. It's what the challenger should be doing.
All right, gentlemen, thank you for your time.
Thank you so much.
Thank you.
Moving right along. Consideration of the sufficiency of the nominating petitions submitted by Scott L. Farida for the office of the Sixth Circuit Court Judge, regular term, non-incumbent. Director Brader, would you read the staff report?
Yes, so this candidate is running for Sixth Circuit Judge, non-incumbent position. This does require 4,000 valid signatures, so it's a large signature requirement. The total filing consists of 4,166 signatures, so the candidate had very little wiggle room here. Almost every single one of those was going to have to be valid to make it. And what we found during our face review was that there were actually 234 invalid signatures, which left the candidate with only 3,932 facially valid signatures, which is under the 4,000 threshold. So we did get challenges, but even before we got to them, we had already determined that the candidate was short. The most common issues were invalid city or township, so it was missing, or it was not a valid name of a city or township. There were some that had date issues, invalid dates, no date. And then there were also some issues where the required circulator information was missing. So those and a few other things were what dropped the candidate under 4,000. There were 2 challenges filed that raised some of these same issues, but we had already determined the candidate was short, so it was not necessary to consider those challenges, and we recommend determining this petition to be insufficient. Sorry, one other thing I'll just mention is there were also some sheets that we saw, not a very large percentage, but there were some sheets that appeared dubious, so we'll be referring those for investigation to the Office of Investigative Services.
Thank you, sir. We have anyone here representing the challenger? I do not have a.
It's not here.
That's a no. You folks all have copies of the challenges. Do you have copies of the challenges? I don't think you have any response here from the candidate. Are there any questions about the staff report?
No.
Any questions about the challenges that we have documentation on? Mr. Cordes? Nobody? Just a minute. If there's nothing we want to go through, I would entertain a motion.
I move that the board accept the staff recommendation and find the nominating petition filed by Scott L. Farida insufficient.
All in favor?
Aye.
All right.
Aye. Next item on the agenda is the consideration of the sufficiency of the nominating petition submitted by Nadine Renee Hatton for the office of Sixth Circuit Court Judge, regular term, non-incumbent. Is there anyone here? Well, before we do that, let's hear from Director Brader.
This was candidate for the same office as previously mentioned, Sixth Circuit Judge requiring 4,000 signatures. This candidate submitted 4,816 signatures. When we did face review, we did identify 247 invalid signatures. The biggest issue there was missing required elements on the heading. So there were some sheets that were missing some of the required elements and resulted in some of the all the signatures on those sheets getting thrown out. But even after removing those, the candidate was left with 4,569 valid signatures out of face review. We did receive a challenge, and it was challenging every single sheet in the petition, so on various grounds. So because they were challenging all the signatures, it was greater than the candidate's cushion of 569 above the minimum, so we processed the challenge. We did accept some of the challenges in that were raised. That the biggest issue was sort of the biggest back and forth between the challenger and also the rebuttal was the issues of the voter being registered. The primary issue involved people who had moved. So Hatton, in responding to the challenge, correctly noted that if you move to a different address within the city or township based on the petition, then that's fine. Your signature still counts. But there were also some who had moved from two different cities or townships, which could not be counted even though they were still within the same district. So that there's a distinction there. So many of the ones that were determined to be not registered based on the challenge were ones who had moved, and not in a way where their signature could still be valid. But even accounting for all those, the candidate was still left with 4,143 valid signatures after the challenge, so they were still over the 4,000 threshold, and we're recommending that the petition be determined to be sufficient.
I don't believe there's anyone here representing challenger or candidate. I have nothing. Okay. Is there any conversation we need to have as a board? Comments? That being the case, you do,
Question
okay.
About the missing required element. I saw, and I can't remember which petition it was that had some teeny little cutoff in the lower left-hand corner. Was it this one?
Go ahead.
Yeah, the biggest with the missing requirement element in this one, missing required element in this petition was in the bottom left corner. There's the warning block of the circulator. The bottom line was during scanning, looks like it was cut off, and I can grab it.
I have a continuing problem with the missing element requirement, but I recognize that the courts constrain us to strictly apply the requirements. And so we had hoped that requirement would change. It has not. So
We've had that conversation here on a
we have
few
had that
different occasions.
conversation quite often, but I just wish that it were otherwise.
Did you include in our package a picture of any of those?
Yes, you should have a copy of the petitions in your packet as well. And it's where there. I can point you to a page number if it's helpful.
This was a little different than what we've encountered.
Yeah,
before.
I don't
It
think
was,
it's-
it was kind of a sloppy cop job. that
Right.
came up.
Yeah. But they know, we all know that that's
We
a
all know what that
requirement.
is, yeah.
Right.
Yeah.
Be it irrational. Okay, I have nothing else.
All right. That being the case, I would entertain a motion.
I move that the board accept the staff recommendation and find the nominating petition filed by Nadine Renee Hatton sufficient.
All in favor?
Aye.
Aye. Right. We have already heard Andrea Banfield's. In that case, consideration of the sufficiency of the nominating petition submitted by Mark Michael Cori for the office of 31st District Court Judge, regular term incumbent. Director Brader.
Thank you. So this one is a little bit complicated, so please bear with me. First of all, what we're putting before you is actually a question of a conditional certification. The Bureau of Elections has determined that this candidate is disqualified based on their affidavit of identity. So we're not asking the board to review that. That's an issue for the Bureau. Typically, when we disqualify candidates based on the affidavit of identity, we don't bring the petitions before you because we've already determined that they're disqualified. In this case, we are bringing it before you just in case because this wasn't sort of a different issue that's a little bit different than things that we have done before. And while we're confident that our decision was correct, just because of the possibility that it could be challenged in court and because of the novelty of the issue, just in an abundance of caution, we want to have a determination made on the petition just in case. So you wouldn't have to come back for another meeting just for this if it does come to that. This is a little bit, sorry to dredge up bad memories, like a little bit like the Cornell West situation from 2024, where there was one issue involving the affidavit of identity and one, the petitions, and they were trying to all going back and forth in court. But in this case, it's a conditional approval. For your awareness, the basis for the disqualification of the affidavit of identity was residency. So in this case, the candidate was challenged as not being actually a resident of the district as of the filing deadline as required, 30 days before the filing deadline as required by the election law. Oftentimes when we get these residency challenges, we're not really able to do much with them because we don't have the capacity to do investigations based on outside or extrinsic evidence to determine if this person actually does live where they say they live. You know, those are typically the kind of things that we just can't really do. We have to rely on what's in the qualified voter file. However, in this case, we did have, you know, a registration date in the qualified voter file that we could go based on. And we also had copies of the petition submitted by this candidate in which the candidate identified themselves as living at another address within 30 days of the deadline. So from our standpoint, that was sufficient evidence from the candidate's own acknowledgement that they were not a resident. And so based on that, we determined that we could disqualify them based on residency. So, but in the event that a court disagrees, we just want to make sure that we have the petition dealt with as well. So that's one complication. Another complication is that I'll go through this in a little bit more detail, but we think that the majority of the signatures need to be disqualified on the petition because of some of these copying issues and scanning issues where words or letters are partially cut off. And so there are required elements missing. But these are all a little bit individual, and there can be arguments either way as to whether some of the things that are cut off here actually do result in the word or the letter missing, or if it's such a small part of the letter or word that it would still be considered to be on the petition and compliant with the statute. So we are recommending it be disqualified based on those missing required elements. But if you disagree with all of those, essentially, there may be enough to conditionally certify this person based on other reasons. So with all that preface, this is a candidate for 31st District Judge, requires 100 signatures. The candidate submitted 127. Of those, we did find in our review, a face review, that there were 91 where there was a missing required element. And it was as a result of copying, scanning, cutting off parts of sheets, cutting off parts of words or letters that rendered the language on the petition not compliant with the statute in our view. And that's laid out in the staff report for you. There were also challenges alleging some of the same issues. So we, based on our review, there would only be 36 valid signatures because of the missing required elements. But if you disagree with us on all of those and think that the required elements are actually present because you disagree with the way we interpret some of these letters being cut off and such, then potentially the candidate would still have enough valid signatures after processing the challenge. They would potentially have 106 valid signatures, not counting the ones that we recommend rejecting because they're missing required elements. So that would be the course of action if you disagreed with us, although even that would still be just a conditional approval because we've separately disqualified this person on the affidavit of identity. I apologize for the complicated scenario here towards the end of the day, but that's where we are on this petition, and happy to answer any questions before you deliberate.
Thank you, Director Prater. We have Mark Corai here. Did I pronounce your name right, sir? I probably didn't.
Yes.
I did. Beautiful. Sir, if you would state your name and spell it for the clerk, and you are representing yourself? Perfect.
Could you turn the microphone on? There's a button for the
It's at the base, sir.
Button.
Button at the base.
yeah,
There you go.
Okay, very good. Mark Michael Corey, it's Koroi.
You have 5 minutes, sir.
Okay. Basically, this is why we're here. The missing required elements, so to speak, they're very slight problems with this required element. I think Mr. Brayer's indicated that if there's anything missing at all, then the whole thing should be stricken. That's policy of Secretary of State, but I'll leave it to this court's discretion or this board's discretion. It's very slight. On the top, on the nominating petitions, a very small portion, a very tiny portion of the nominating petition, the lettering is been cut off. I believe it's enough to clearly read it. Then I think there's 3 additional words which are partially cut off. You can all read all those anyway. They're not already cut off, but kind of partially obfuscated. There could have been a hair or some piece of dust where those were being copied. I think it's a very minuscule, very infinitesimal, small type issue. In fact, other than nominating petition on top, the certificate circulator where this other issue appears, where there's I think 3 partially obfuscated words, is an area for non-state circulators. I have 3 circulators, myself and 2 other people, all are in state, all are the same city in Hamtramck. Okay, so it was a relevant portion of the entire petition. So I believe under these circumstances, it's totally inequitable to disqualify those entire sheets. We believe that the board should exercise discretion and look at this and say, well, it's a very partially obfuscated word here, very small words. It's a thing that's been applies and irrelevant to the actual certification because it deals with out-of-state circulators, which I have none of. And at the top, it's only a very, very minuscule portion that's cut off the top on these. To throw out 6 petition sheets to put me under 100 would be an extremely difficult thing to do, extremely draconian measure to do by this board. And I don't see any kind of real in the law, any type of precedent for this extreme type of disqualification. As Mr. Breyer indicates, I do plan on attacking the affidavit of identity based on constitutional language, indicating I am qualified. So there's a possibility of reversal there. That's why we're here today on the conditional issues involving the missing required element argument. So I would just ask this court to take a common sense approach and to deem the petitions sufficient based on the dismissal of the missing required element arguments.
All right, sir. Questions from the board?
I have a quick question. So it's actually for Jonathan. If we were to decide that those elements where the lines were cut off were not a problem, you're saying that he's still may be disqualified?
So if you determine that the elements are there,
Yes.
like if the circulator, if that is there in your view, then there would, in our view, there would be 106 potentially valid signatures, which would be enough. So but that would be conditional because we have separately determined, the Bureau of Elections has determined based on the affidavit of identity that the candidate was not a resident as required. Now, as indicated, that could be challenged. And in the event that our decision there was overturned, it would be better, that's why we're putting this before you
I
now,
see.
so we don't have to bring you back just to certify a petition in that event. So
I see.
if you disagree with us and you think that this required element is in fact there, we would say that he does have enough signatures on the sheet. And if we were also wrong about the affidavit of identity, then he would have, in our view, potentially enough signatures to qualify.
Okay.
Fortis,
No, no question.
Vice Chair.
No questions.
I'm looking at the copies of the nominating petitions that we have here. Are they all consistent with the idea of just the top of the N and the top of the O, or are there more than that?
Also some of the.
There's more.
Certificate of the circulator on.
This one.
Cut off down here, okay.
Well, there's like a little white line that kind of goes
Yeah, there is.
through
Yeah.
some of them. I mean,
You have 'em?
I still agree that it is
Here.
pretty minuscule. And
These are the originals.
Here's the originals. Do you wanna,
It's pages 9 to 13 and 15.
So there's two issues. There's the issue with the bottom left on the warning block and the warning where it's cut off. There are 4 sheets that I said that it was not legible. It's that kind of like white streak that you see is present in a number of the sheets, but there was only 4 of them that I thought there was not enough there. That's sheets 1, 5, 6, and 14. The other like element issue is the word nominating at the top of the heading. That's sheets 9 through 13 and 15, where the O has kind of turned into a U, but everything else is there. So those are like the 2 separate issues. And then the respective numbers are in the staff report as well. Like for each of those issues, there's the breakdown for the respective number of signatures.
In this case, I think the board's aware of this, but it's not an issue of, a policy or discretion or sort of substantial compliance. It is strict compliance, but it's up to the board ultimately to determine if this does strictly comply because these words and letters are actually there. And that's really, we think not for some of these, but ultimately it's your decision.
So if you say the letters are there, are you saying that there's a certain percentage of a certain part of the letter that is enough? I mean, that seems to be.
Yeah, go ahead, Adam.
If it's helpful, when I was looking at the warning block, I was looking at, can I see it there to be able to read it? Or is it just gone? Not so there were several sheets in there where I could see enough of the warning.
Yeah.
It was faint, but I can see it and I counted that and said that was fine. And it was not cut off.
The sheets you gave us for the ones that are not counted, is that correct?
No, that's the entire petition.
The entire
The
petition.
sheets that were not it's sheet 1, 5, 6, and 14 are the issue with the bottom left that I
You
could not.
1, 5, 6, and 14, you said? These are out of order now.
They're hand marked, so that's okay.
Okay.
I can fix it.
This is so interesting
Can we just lay these out a minute?
because they're not so much different
Yeah,
from the ones.
Here, let me stand up so we can all get in. How's that? Let's just look at them one by one. How's that? It's only this group, so.
It's only this group, but these are a bit different.
right.
Yeah. No.
So
So is it this though? I think, are we talking this?
Here.
Yeah, that?
this little, right.
Right
so-
here, and the other one we're talking about is, so let's deal with them ones at a time. here.
Yeah.
This idea of the top being cut off
I
in
know.
nominating petition.
So
I'm not sure that those should not pass muster. I mean, that's,
I agree.
yeah.
Yeah.
So these, it's really more this comes down to this mark down here, right?
Just that.
I mean, I guess my question would be like, does this prevent,
Say that again.
does this prevent you?
No.
I can read it.
I can
but,
figure out.
Read it too, but the thing that maybe Mr. Fracassi can enlighten us on is it
Why
doesn't-
that one and not that
it doesn't, yeah, because they all have that. No, they don't, okay.
They don't.
But this,
Yeah.
this,
This looks more, it's got an issue with running out. No.
okay, so this one actually looks worse to me. than
That's the same as these
Right, and they weren't.
on the bottom. I can still read that though. I can read the form number.
That's better.
11/2019, moved by the Director of Election, Ada Mitchell.
Whether
you
it's
wanna-
those four or whether it's all of them, I think the real question is just, is that enough to boot them? The signatures.
Right.
It's hard for me to come to that.
Me too.
Very difficult.
Director Brader, if we looked at these and allowed them to continue as you've invited us to do.
All of them?
Yeah, if we looked at these, because what we're focusing on is this work.
You think that's on there?
I think that's okay.
Okay.
And what we're looking at is really kind of this mark down here.
Yeah.
And I do know that you're gonna have a line from, I can read that. If these were put back into the universe.
If you think these were all good based on, they're not missing required elements, then we would say that it has 106 valid, so that would be the conditional certified.
It's not like, it's on, it's in the.
Yeah.
It's a little bit
So
farther.
if you think
Go
those are all
farther down
good,
on the staff report.
if you think those are all good, then our recommendation would be that the candidate does have 106 valid, which is.
Can I ask a question, since this is my first time through? Has the board ever bounced petitions with similar errors?
We've had a couple that have come very close.
Okay.
Matter of fact, I always go back to the pastor from Detroit that, but he had, but in fairness though, I remember that petition, there was more than just a partial line missing. There was that entire bottom line was gone.
We typically reject sheets if there is something that is cutting it off that essentially turns it into a different word, or if it's missing. That's typically why we would reject the sheet.
And I would say, I mean, this analysis, that is based on the way we typically do sheets, is that
Yeah.
like we understand, like we know what words on there, but we are looking at it as like objectively, is this the word? So that's consistent with our past practice. Having said that, every single one of these is a little bit different, right? Which is why ultimately it's your decision and,
Well,
it's your,
yeah.
your statutory responsibility to determine if the word is there. We are just making a recommendation.
I was more asking if the board has gone against your recommendation when it's been similar.
You've gone against a recommendation before. You're not offended. I don't know if it's happened in a situation like this. Can you remember one like that?
Not
I
in
don't
a
know.
situation like this. One way or the other.
I think there have been some things where there have been different interpretations of some of the invalid signatures. I think at this point, we have mostly incorporated those kinds of decisions into our manual, so that's not happened
I
as
see.
much recently.
Okay.
But yes, I mean, the board has and can and has gone contrary to our recommendation before.
Okay. Oh, there. Oh, yeah. well,
They're here.
Yeah.
Okay. Also, just want to note that there is a challenger
I
here.
have a challenger.
There is a challenger who wants to speak too, I think.
Okay.
Someone wants to speak though.
Oh, sure.
Oh,
Come
sure.
on up, ask us. Turn on your mic and tell us who you are.
Good afternoon, board. Olivia Flower, OLIVIAFLOWER. I'm here today on behalf of Miss Andrea Ellen Karpinski, who filed a sworn complaint challenging Mr. Corey's eligibility for the office of judge in the 31st District Court. So I just want to make sure Director Brader did a comprehensive job in sort of outlining the myriad of issues we have going on here, but we just want to make sure that the context isn't lost, that in an apparent attempt to qualify for the ballot, Mr. Corey changed his address from Warren to Hamtramck on the day he filed his petitions and his AOI on April 21st, the last possible day to run in the August ballot. In Michigan, the law requires those running for district court judge to be a qualified elector. That bar is not particularly high and is constitutionally mandated. You have to be a U.S. citizen, 21, a resident in Michigan for 6 months, and reside in a city or township for 30 days. Mr. Corey changed his address on the day of the filing deadline and is not eligible to run. I think that's a separate issue that's before the Bureau. But we do recognize that there's also this issue with his nominating petitions. We urge the board to determine that Mr. Corey has not collected the requisite number of signatures. The standard, you're well familiar with it, Stand Up for Democracy. Whether you think it's rightly decided or wrongly decided, it's the current standard by which this board measures its compliance with the Michigan election law. So we assert that the measure of that is not, if every petition were determined by having to convene around it, that really turns it into quite a subjective test. It should be whether the elements are there or whether they're not. In this case, they're not. And as a result, Mr. Corey has not collected the requisite number of signatures. We also think that there's an important issue that the board should be aware of in the event that you do think those elements are there, that we have alleged that certain sheets 2 and 7 contain indica of forgery. The Bureau reviewed and determined that only 2 of the signatures that we challenged did contain that indica of forgery. The individual that circulated those petitions, it's important to note, is on trial for forging election absentee ballots. I think it's an important judicial note to take in the context of your review. So if those 2 sheets were also deemed invalid, it would take him below the threshold. So we believe that the board should, consistent with staff's reports regarding these petitions, find that Mr. Corey's petitions are missing statutorily required elements, and whether that be a photocopying error, actual omission. I think when you start to get into that, why is the element missing, or how much of it is missing, or can I read it, can you read it? That departs from what the current standard is, and it makes it harder to implement uniformly across the hundreds and hundreds of candidates that you review each election cycle. So we believe that the board has a clear legal duty not to certify Mr. Corey to appear on the August ballot, and would leave it open for questions.
Before I open it for
Yeah.
questions, Ms. Flower, there are certainly within the province of this board the ability to look at things that may not be a complete missing element. And these are elements and there may be somewhere where it really is close, and that is our discretion. And we've used that discretion very carefully. And as you know, you've been before our board before. So that's one issue, that there are times when something falls under is this a missing element or not? The elements that this group is looking at here are all here.
That's the question.
That's the question. Of course, it's always the question, right? The distortions that you're referencing that are classified as missing elements, we still have the ability to look at here. So that's one item. The other items you're referencing are more affidavits of identity items, aren't they?
Initially
And,
started
and
talking
you're
about
saying,
affidavit
and
of
you're
identity.
acknowledging that.
Oh, certainly, yes. There's, our challenge was addressed to both the Bureau and the board, acknowledging that those are two jurisdictionally separate issues, just looking to provide the entire context.
But what your position, as I understand it, is that under Stand Up for Democracy, they're either there or they're not. They're not partially there or arguably there.
That's the,
Okay, yeah,
Yeah.
it's a good issue.
It is a good issue. It's
Right, and it's one that we grapple with.
every time.
And what I hear Mr. Fracassi saying is that if it's sort of there and you can discern, you can read it, then it's there enough. I'm just trying to, because we have a strict compliance requirement, we're grappling with what that means, right? And if a word is partially there but legible, is that strict compliance?
It's a word, yeah, I mean, in this particular case, these are words that are, do you have a problem reading what that word is? Would you like to use mine?
but I think it's important also to,
I won't.
it's not whether the word is relevant to the understanding of the petition or whether you can read it or not, is it there in the typeface that's required by 554C? And if it's cut off, then it's not there in the typeface required by 554C.
Or faded or bent or.
What were the sheets where you said the circulator is
We
being
alleged
charged with
2
fraud?
and 7.
2 and 7, okay. Yeah, I just want to.
Have 5 invalid signatures.
Yeah, okay.
We're double checking, but I think those were challenged, and if we determine the signatures did not match, those would be reflected in our updated, potentially valid total, which would be 106. So that potentially valid total includes 5 invalid signatures, which I believe include the alleged forgeries. So that wouldn't change that recommendation. I guess if it's helpful, the way I think about it when I'm looking at this is, is that a C? Is that if the circulator, are those letters IF space THE space C? Is that what's there? And the word otherwise, like, is that an OTHER? In terms of the strict compliance, like that is the way I think about it, is that actually that letter that's on the sheet? Even if part of what normally looks like an C, even if part of that C is not there, is there still a C left? Or is there something else? Is kind of the way I think about it, if that's helpful.
I don't think that there's still enough of a C left there or enough of the other. The wise is there, but not the other. We haven't been in the position where we're looking at ballots with magnifying glass, but it does happen sometimes. And maybe we do need them, but I'm additionally a bit puzzled by the fact that the missing parts of words are missing in more than just the petitions that were identified for us. Because I think other petitions have the same problem. So I think that this is not strict compliance.
Think it is not strict
I think it is not strict compliance.
I'm not for it. I could still think. I'm not sure that's a missing element. I'm looking at the same thing.
How do you define element?
I look at it as pieces that are physically missing or things that are missing that are contextual in there. We've seen that before where we've seen people come in and it's cut off down here. The line's missing. We've seen it come in where the bottom of this says warning, circulator knowingly makes false statement and it's cut off. That's we're missing element.
I think excuse me, I think we've even seen it, Mr. Prakasi. Have we seen it where there's just a letter that is completely cut off and that's missing? So what we have here is letters that are partially obscured. And what Director Brader is saying is that if there's enough of the letter there to make it legible, that it's there. And, you know, it is, it's a real quibble, but we have to make a decision. So I would say that they do not strictly comply.
It's coming. What do you think?
They do not.
4 days. What do you think? I know, so do I. So where does that leave us? 2 and 2. We are. We didn't vote on it. It can't be that long. We're still discussing.
Deadlocking means that it's not certified.
Correct. Right.
Yes, that's right. With Mr. Johnson, right?
Yeah, so, if you need 3 votes to get certified, understanding here still. But, okay, 2-2 is essentially the same.
So what we're talking about is if we put these sheets in, it changes the count, which would make the count higher. If you leave these out, the insufficiency continues. I'm not sure how you would put that, and I'm not sure which way you want to do the motion. You can vote yes or no. I mean, but if these sheets are out, it's insufficient. Right? Is that what I hear you saying?
But either way, if there's not a third vote, then it goes with the staff report, which is whether it's.
I mean, so you need 3 votes to make the ballot.
Correct.
It doesn't necessarily matter what the correct. We recommend it on that block. So not, right? So it's like some sense it's like try don't vote. So either one would succeed, but the one that he needs to get on the ballot is you certifying him to the ballot, which would need 3 votes. And that would all be conditional anyway in this case.
We accept the staff report. And it's conditional.
I guess, so I would, let me, feel free to correct me, but what I would recommend, if you are 2-2, what I would say is you could either do 2 motions, like first you could consider a motion on our staff report, which would fail, like accepting our staff report would fail 2-2, and then you could also do a motion to reject our staff report and put them on the ballot conditionally, which would also fail 2-2.
Right.
I think just for the record, I think it would be just good to have a vote on the attempt for him to get conditionally certified so that it's on the record that either succeeded or did not succeed, if that makes sense.
I move,
Okay, they seem to agree.
I move that the board reject the staff recommendation and find the nominating petition filed by
Spell it out, Mark's name.
Markoi, sufficient.
Been moved. We have a second.
Can I interrupt? For both of the motions, can you just add the word conditionally in there?
I move that the board conditionally or reject I move that the board reject the staff recommendation and find the nominating petition
Additionally.
filed by Mark Coy conditionally sufficient.
Second. I will. I'll second it. In favor?
Aye.
Opposed?
Nay.
Nay. Now are we doing it the other way?
I don't think that's necessary.
Okay,
Yeah, that was the only notion there. So
okay.
legally, procedurally, from my standpoint, and anyone can feel free to correct me where this stands, is now what this means is for the candidate to get on the ballot, the candidate would need to successfully challenge the Bureau's decision on his affidavit of identity, which would have to be done in court. And then also the board's failure to certify the candidate to the ballot, which could also be challenged in court, essentially. That's where this would leave us.
Right.
Thank you.
Thank you.
I think it is. We have one more, don't we?
Okay. Next item up. Good. Yep. Consideration of the sufficiency of the nominating petitions submitted by Craig S. Datz of the office of 71B District Court Judge, regular term incumbent. Director Brader.
So this is a candidate for District Judge 71B. It's an incumbent position, and it requires 200 signatures. The candidate submitted 272 signatures. Following face review, we identified 10 facially invalid signatures. 9 of those 10 were because of heading issues, not including required elements on the heading, but that still left the candidate with 262 facially valid signatures. There was a challenge filed, and the challenge was raising multiple issues and did call into question 101 signatures, which is more than the cushion that the candidate had left after face review, which was 62. So we did process the challenge because it was enough in question. The predominant issue here was that on 20 of the sheets, the challenger was arguing that the heading was altered because the letter B appeared to have been added at some point after the 71. Essentially, I believe what the challengers are arguing here is, in the challenger's view, the header said 71, then all these people signed it, and then after that, the candidate or somebody added the B after the fact. From our standpoint, like, it certainly does look like the B is written in heavier ink in some cases than the 71, but we're also not able to determine that happened, that means it was added after signing. It could have been added before signing. It could have been already on there, but, made more, sort of gone over to make more prominent or to make it, I'm just speculating, it didn't look enough like a B or whatever the concern is. The point is, we can't really tell if the B was added separately, when it was added. So we didn't have a basis just based on that to say that these were all added after and the header was invalid, essentially. So we rejected those challenges that were based on that. And then there were some other challenges that we did accept for other reasons, mostly the signer not being registered to vote. But after processing all those, it still left the candidate with 246 valid signatures, which would be sufficient to make the ballot. So we're recommending that the board determine that the petition is sufficient.
Right. Is there anyone here representing is there anyone here representing the challenger? Or anyone here representing the candidate? Discussion, questions? Mr. Cordes?
No.
That being the case, you have a motion?
I move that the board accept the staff recommendation and find the nominating petition filed by Craig S. Datz sufficient.
Moved and seconded, all in favor?
Aye.
Aye. Right. We are down to public comment and new business, but before we do that, are we at a position to look at numbers?
I think we are. Staff is, Adam and a couple other staff are going over that right now. So we could either take a brief recess or if you, I don't know if we have additional public comment. But either way, I think we would need at least a few minutes.
Okay. We will break, we will be back here at 2:45. 10 minutes, 15 minutes? We're returning to talk about recast numbers or re-explain the numbers.
Yeah. Yeah.
Yeah.
So hopefully this is beneficial. I appreciate everyone's patience. So what the staff report does is essentially it is a redoing of the staff report the way we should have done it because we, as noted, there were some other challenges that we should have processed. So just quick recap of the sequence of events. So we put out the staff report, or we received the challenge. We determined that there are 1,573 facially valid signatures. We received the Kirk challenge. We determined that we don't need to process some number of the remaining signatures because it wouldn't be enough to make a difference. So we put out the staff report a week ago. Just 48 hours and 2 minutes, which is fine. Before the meeting, we get the Doster submission. Now, Doster did not challenge signatures and cannot challenge signatures because he didn't do it by the challenge deadline, but he can submit information to the board, which he did timely. And Doster points out in his comment to the board that we should have actually processed more challenges than we did. And we agree with him that we should have done that. So what we have now done here is redone the staff report the way it should have been done, essentially, with all the challenges reflected. So where that leaves us is we had 1573 that were facially valid. We had 752 that were challenged for reasons other than the all reasons. Okay, sorry, we had 752 that were challenged for all reasons, and we should have, because that's greater than the 573 cushion that he had, that Lujarai had, we should have processed those. So this represents the fact that we have processed a substantial chunk of those. We have actually processed 476 of those 752 challenges. And when we did that, and did those all involve individual lookups? Yeah, so the 476 challenges all involved individual reviews, lookups of the signatures and the voters. So of those 752, we reviewed 476 of them. And after that review, we did reduce the number of valid signatures down from 1,573 down to 1,361. And the biggest drivers of that reduction were invalid signatures, non-matching signatures, of which there were 81, and 80 where the signature was not, person was not registered to vote. When we got to that point, we were left with 1,361, and so we didn't process the remaining 276 because it wouldn't take, even if all of those were deemed to be invalid signatures for whatever reason, it would still leave the candidate over 1,000. And so that is, and just some of the numbers are a little bit different because there was a claim about the number of signatures that were reviewed on FOIA. We disagree that it was like 752 versus 749 or something like that, but we're just giving the benefit of the doubt to the challenger and assuming it's a bit higher. Either way, even if we accepted all the remaining challenges and took those out of the total, the candidate would still have more than 1,000 signatures. And this does reflect all of those dubious signatures that were mentioned, so the ones from July and the other circulators that were properly challenged, it does include the review of all those. So that's where, that's, our recommendation stays the same, but hopefully with a better explanation. And I appreciate everyone's patience and apologize for the lack of clarity on some of this stuff. Having said that, Adam, is there anything you want to add or clarify? Okay, so that's where we are. So we would still recommend determining the petition to be sufficient.
Comments? 4 days? Because it's you.
What Director Brader has just gone through is a whole new staff report. It does not reflect the May 14th staff report that we saw walking in today. Talked about Kirk's other challenges that I thought the staff correctly rejected, the 180-day one, the paid for by. That's not reflected in this staff report at all. But so this is a whole new staff report, and I told you I'd be brief, and I will. I'm just going to read to you MCL 168.552 sub 10, and it states, I'm just going to read the first sentence. At least 2 business days before the Board of State Canvassers meets to make a final determination on challenges to and sufficiency of a petition, the board shall make public its staff report concerning disposition of challenges filed against the petition, end of quote. We just got this. That's all I have to say.
Right.
You,
But
go ahead. No,
Well, so-
you take off there.
to be clear, our staff report is still our staff report from May 14th. That's what we're asking you to consider. We put this together for illustrative purposes as supplemental review. So it's not that we are throwing out our past staff report. It's that we're supplementing it and explaining the way that it would have looked if we had processed the challenges the way we should have. But the finding of the initial staff report still stands.
So even if this were put off, this same report is exactly what would appear. There is, I mean, the deadlines, anything that was, that piece that was received 48 hours before, piece that was received the other night, we're not even going to consider that. You're talking about a deadline, is that correct?
No, I'm saying that the statute says that you have to make public your staff report
Right.
2 business days before you act on it.
Okay.
And so what I'm hearing Mr. Brader saying is, no, you can go ahead and adopt the previous staff report that was submitted 7 days ago that would have met this
In which
2
case,
business.
this would be the new staff report that now has to be up 2 days before. Is that what I hear you
That's
saying?
exactly what
I'm
I'm
just trying
saying.
to hear what you're saying.
Because you're going to make a motion saying we move to adopt the staff report or something like that. And you can't adopt the staff report that was given to you minutes ago because that directly conflicts with MCL 168.552 sub 10, which says you have to make it public 40 or 2 business days in advance. Well, you haven't made it public 2 days in advance. So you can adopt the one from a week ago, but then you'll have done something that no board in the history of the Board of State Canvassers has done, and that is knowingly adopt a false report. So
Why didn't you argue that earlier today when we said what we were going to do?
because I know exactly, I wanted to see a staff report
That
in
doesn't
front of
make
me.
sense. That doesn't make
Absolutely it
sense.
does,
No, it
because
doesn't. We said what we were going to do. We were going to explain more fully what happened. You agreed.
I didn't agree. I wasn't speaking.
You didn't say anything. We were. we
I'm
were
saying
addressing
something
you.
now. But, well,
Well,
you're
it
the board.
seems
You
like
can,
you're late on everything. You were late on your comments and now you're late on this.
that's all I have to say.
If I might.
Thank
So-
you. Thank you for the opportunity.
I disagree that it is a false report from May 4th. I don't agree with that characterization. We do sometimes have errors in our staff reports. Like, we do our best, we make mistakes. That's part of the reason that we have them posted in advance, that people can respond to them and make comments to you. Ultimately, the way the board has operated is you don't have to agree with every single determination on every single signature we make on a petition to approve or accept or reject our nomination. You have to agree or disagree that ultimately we're correct about whether or not the petition has a sufficient number of valid signatures. Our report from May 14th, although it did include errors because we should have processed more challenges, and I do appreciate Mr. Doster raising that he's absolutely correct about that. Even though it did include errors, it was ultimately not a false report. It was a correct determination that the petition included a sufficient number of valid signatures. I don't see any prohibition on us providing you and parties before the board additional illustrative information to explain why the ultimate determination was correct, even though the report included errors. And I think that's what we've done here. I would also just note that although, yes, we have time right now, the board is often acting in a situation where it is right against a deadline, and it cannot be the case that the board cannot act on something if there isn't some kind of error in the staff report without, taking 2 more days and missing other statutory deadlines. So that just wouldn't make sense if that were always the rule. So with that, I would certainly appreciate where everyone's coming from. I understand the perspectives, but I think that the staff's initial report, while not perfect, was ultimately correct. And I think this simply illustrates why that was the case.
Again, the only other option I know is listening to, if there's a legal requirement here, the changes that were made to the staff report, should we post those and add this as simply an option on the 28th? Here's the thing, we're not going to take any new challenges. We're not going to take any new challenges. We're not going to take any new, so what would it be as if it was on the 28th? Is it what? It's an acknowledgement and a vote, right? It's the same vote we would take right now.
What makes sense to me is that there was a recommendation to determine the petition was sufficient based upon a conclusion at that point that there were 1,316 valid signatures. And now there has been a recalculation. One valid, more than had initially identified. I think the reason that staff recommendation to find the petition sufficient.
My concern is that I don't want to see us do something that in the next cycle, all of a sudden comes back and we open up we open it up to changes get made in a document. Well, yeah, here's a requirement, but we're only making this change. Not that this board would do that, but there's others coming after us.
So if to consider this as a new staff report, which I don't think it is, I think the staff report still stands. We've just explained it in further deal. We provided you a document called supplemental review. It's not a replacement staff report. But to do a new staff report, what we would need to do is republish some combined version of these documents today, consider them on the 28th. We're not considering any new challenges. So the outcome is going to be the same unless there's some issue that I'm somehow not grasping here. But the other issue, just more broadly, like going forward, is I do think it's certainly, I wouldn't say that there is never a scenario where there's a problem with a staff report and the board can't say, we want to consider this at a later date. Like if there's some, major problem that is totally rendering the determination incorrect, where there's some lack of clarity where you can't either just accept or reject our determination that day, there may be cases where it does make sense to kind of go back to the drawing board to some extent. But that I do think that should be the exception because it's going to create a totally unwieldy and unnecessary process when in fact what the board's process is now does allow for people to take issue with our recommendations, present that to you, and have you make the determination on it. And that's based on, the way we lay that out is, we have a challenge deadline, we have publicly available documents, we have a challenge deadline, we have a staff report deadline, we have a deadline for people to respond to that staff report, bring issues before you, and then we have a period of time for you to decide, which is where we are today. I don't see, although I wouldn't say that, again, this could never happen, I don't see anything here that would necessitate sort of going back with a new staff report, given the fact that I think we've explained that our staff report was ultimately correct in its determination. I don't think the fact that we produced another document called a supplemental review for illustrative purposes somehow renders that original staff report void or superseded. So I don't think it's necessary, but ultimately it's the board's determination.
I guess that's, you know, when you say new staff report, I see it as the staff report with an addendum or with an amendment. You're changing some wording. Does that make it a whole new staff report? That's what that's what Mr. Doster's arguing. Does it make it a whole new staff report legally? I mean, in effect, what we're discussing here is something that has to do more with transparency, right, and optics than anything else. Is that it? I know that wasn't fair to throw out that way. You are making a change. If we were sitting here talking about, if we were talking about a petitioner, if we were talking about all of the other subjects we've talked about that required change, and it was changed here at this table, it would be sent back and reposted, right?
Only if the board only if the board felt that it couldn't make a determination that day, because you effectively, anytime the board doesn't accept a staff recommendation, the board is changing the report, you know, in a sense. I mean, our report is a recommendation.
Correct.
The board's action is the determination. So we don't redo a staff report, for example, when the board rejects our recommendation. The staff report's there, the record shows that the board didn't accept the recommendation, and that's the end of it. So you know, and similarly, you know, in other contexts, we might have other folks come up and point out issues with other staff reports we made. You know, maybe they think we're wrong about some individual determinations, but it doesn't ultimately affect the ultimate outcome of whether they have sufficiently valid signatures. And we don't redo a staff report in that instance either. I think the only reason we produced a document here was because there were a lot of numbers being thrown around. Admittedly, we didn't process some challenges that we should have, even though it didn't affect the outcome. So we provided this information today for illustrative purposes. Again, I don't think that represents a revision of the staff report that necessitates reposting it. But if that were to be the case, then what we would have to do is put up some version of it today and then have the board consider it a week from today.
Well, it doesn't, no, in the incendiary climate that's out there right now, I guess where I'm trying to go with this is I really don't want to wake up tomorrow morning and read, you know, in the Detroit Free Press or the Detroit News or anyone else that somehow we, you know, voted an invalid report or put something invalid through. Neither does anyone. Now, having said that, I'm open to whatever you want to do, but I'm saying that if that's gonna, if the decision is ours, I guess that's what I'm saying is.
Decision.
Heather, what do you think?
I'm sorry, can you repeat? I was just talking to them. Can you repeat the question, Chair? I was canvassing on what to do with the supplemental staff, no, not a staff, supplemental analysis that was provided today.
I don't think there's anything, it's not a new staff report. The Bureau complied with the statute by publishing a staff report timely.
Is the Bureau obligated to publish an addendum to a staff report?
It doesn't, the statute doesn't address, it doesn't say you can't. And it would be, I think I agree that to read the statute as never being allowing the Bureau to provide you additional information like it did today, do a supplemental analysis without publishing it would be problematic, and I don't read it in the language, today, just looking at this issue, so. But ultimately, I think it's within your discretion to decide what to do, but there's been no violation of a statute here.
I mean, it's not going to change anything. If we took a vote on this right now, we've already gone through all of this. We've already looked at this. We've already looked at the challenges. We've looked at the responses. And quite frankly, we've seen the addendum. Or not the addendum, I'm sorry. We have seen the adjustment that was made.
It's actually more transparent.
I'm
No.
sorry?
It's more transparent, what we've done today.
I think it is.
If for some reason it was gonna change, based on, our speakers today and who came up and spoke, if it was gonna change it, then we wouldn't go forward right now. We would have to, put it on a different agenda. The fact that it doesn't change the recommendation, to me, is reason to go forward.
The only other thing I just want to throw out is 2 years ago with the Nielsen situation, you all probably remember if you were here. So Adam, do you just want to explain what we did in that scenario?
Sure. So it was very similar. So the board's meeting was on May 31st, and that was, excuse me, that was when we were getting things literally like 5 minutes before the meeting was starting. We were still getting supplemental information. What the board asked staff to do in that instance was to take this information and go back, and we came back on Monday. I, along with staff over the weekend, we processed the challenge and sent out a supplemental review. I have the email up, I sent it out at 6:38 p.m. on Sunday. So that's it where we broke down, here's all the things, the additional information that the board asked us to look at. It was not a staff report, it was just an additional information that was provided. The staff report had already been provided. And then the board met on Monday, June 3rd, to finish the certification meeting. And did vote on that Nielsen staff report that was originally filed and the Bureau's recommendation, on Monday, June 3rd.
I remember that meeting.
Right, and on Monday, they came in with additional information,
Well,
which is
and that-
what led us to say,
It's 48, yeah, right.
but
I guess, I mean, just to be totally clear, if,
Mr. Young.
what I'm asking is if you don't have to recast an entire new report, you would go back to the office, you would take exactly what you've got here and you would post it up as the revised report. Is that correct?
But it's not, because
not
it's the same recommendation.
Say again? Nothing.
It's the same recommendation.
It's the
Same
same
recommendation.
recommendation.
And that's what counts in the staff report.
The
is
numbers, Hannah.
recommendation. You
It
can,
doesn't matter.
If I'm hearing this right, you met your statutory duty by putting out the staff report. You gave us additional information. In many ways, your staff report doesn't really matter because we can do whatever we want. You provide. People keep saying we're in charge, so I'm just making sure you guys know. So the argument that this is a new staff report is not. This is just additional information. And I guess the big question here is, do we feel that we have the information that we need to make a decision?
And
There's another. I don't know if you want to recognize people.
you know what? No, I'm not, I let Mr. Doster, and you know what? We're going to bring this to a close. No, I don't want to reopen all of this up. We're having we're trying to get through something here that doesn't involve It involves a process. It involves a notification. You're not, you're not really changing this. You could have also put this document together in our break. This document could have put together without ever touching the staff report. You could have put a supplemental memo next to it, right?
Yeah, and I would say, I mean, that's what this is. It's
Okay,
just-
that's- I mean,
yes,
that's
it's
exactly
presented
what
like a staff report, but it's not actually an amendment to the staff. report.
That means all what we're arguing here about is we're arguing about format on a piece of paper. You could have just as easily taken a blank piece of paper and said, we're going to give you an explanation of how we wrote the staff report.
Yes, I agree.
And we would have never had this far in the conversation if we had done that.
Likely not.
So why don't we do that and just keep it out? I mean, why don't we just say that we've done that or let me pick my words more carefully. Can we vote on the original staff report that was presented to us today? And can you take whatever changes you've got here and just make them a memo that would be added to the minutes of the meeting?
Oh, okay. Yeah, I mean, yes, the short answer is yes, we could do that.
That would mean that the staff report under consideration is exactly what the staff report was.
Yes.
That'll work for you. Does that work for you?
Sorry, was that a question for me? Yeah, it works for me.
Asking
I mean-
Heather, but you were looking at me so nicely. that
Oh,
I thought,
okay, no. Oh,
Yes.
okay, sorry.
Works for me.
What's that?
Determine. the
No, I get it.
benefit.
I know where we're going to here.
Right.
Again, it comes back to optics and it comes back to
Well-
how the story gets told.
Right, but our staff report comes, and we can quibble about it and we can say, but it should, this number should go up and that number should go down. But the question is, are we finding the petition sufficient or not? That's our obligation. Yep, right.
Is there any other discussion on this? Is that? Is that a reasonable way to go forward?
Yes,
Is there any additional discussion on this?
no, I think we need a motion.
All right.
There is our motion.
Sure. I move that the board accept the staff recommendation and find the nominating petition filed by Robert Lugeri, Lugerage, sufficient.
Second.
All in favor?
Aye.
We have any public, there are no public comments. There's no sheets up here for public comment. Is there any new business to bring before the board? That being said, we're adjourned at 3:31.